38.
Oh my goodness.
Okay. Well, any urgency in the matter? Okay. Both sides are represented with consent of the other side. Mr. Amdas, counsel for the opposite party, prays for some time to file objection in the matter. Prayer is allowed, list after vacation.
Item number.
49 is stay matter. No, day means it goes after the vacation. It's a stay matter. We'll have to consider it. That I don't know, but it's a stay matter. It can't be automatically extended. You wait for your turn. Renew the prayer when the matter is called on board. Yes, next. $25. What is the agency? Okay, we'll take up. I'm not assuring when, but will take it up. I'm making a mark. We'll take it up. Agency. Okay. Item 64. Yes. You're praying for adjournment. Okay, on the prayer made by Mr. K. M. Hassan, counsel for the petition. The matter since adjourned today. List after ensuing vacation. Okay, interim out of past release stands extended till the next roll listing. Is the service complete? You have taken steps. Okay. Yes. 69.
Has already participated in the tender process since he has not got the he has for this. There's an interim order regarding the school buses.
School bus. Okay, we'll take it up. I'm not assuring when, but we'll take it up before rising. You ask the other side to be here. MSc appeal is not so urgent. After vacation. It may be pending for some time, but is the time to mention for all the entire 3 years or 4 years it was pending, you did not wake up. It's a case of Rip and Winkle. You just wake up and then you want it to be taken up before vacation. Do we have that that amount of time? After vacation. Why you are making me retaliate? Just before the vacation, last day tomorrow, when I have to finish all my work, sign all and release all the papers, then you want this MSCT matter to be taken up. Don't be a Rip and Winkle. You could have done 10 days before. You have heard the story of Rip and Winkle? No. Look at the internet. Rip and Winkle is a person who slept for 20 years and he woke up and he found the world different. We were taught this lesson when we were kindergarten, what you call students. Yes. 11. You want an adjournment? You're for? Oh, appellant. Okay. On the prayer made by and counsel for the appellant, matter stands adjourned today. List after ensuing vacation. Yes.
Fine.
65. Okay, we'll take it up. Okay. We'll take it up. I'm not saying when, but we'll take it up. Okay, you have a consent. Okay, we are recording it, but we'll take it up when the matter is called. Correct? Mr. A. Iqbal. G. Iqbal. G. Imtiaz, I'm sorry. Okay. We'll record your presence. Yes. Please speak loudly. I'm unable to hear you. Speak loudly.
Item number.
Item number 19. Yes, what do you want? Adjournment. Okay. You have taken consent of the other side. Your name? Please speak loudly. I'm unable to hear you. I'm still not hearing you. On the preliminary basis, counsel for the you have counsel for the applicant or respondent. Respondent matter stands adjourned today. List after ensuing vacation. Yes. 52.
That's part of the instruction about that I want to introduce.
Okay. 52. Upon instructions, Mr.
Muhammad and
Mohammed Imran, counsel for the counsel appearing on behalf of Mr. S.S. Sigdar, counsel for the petitioner, seeks to withdraw this application. Clear is allowed. Matter is dismissed on withdrawal. Interim order, if passed today, stands vacated. Yes. $60? 39. Okay. 39, somebody has mentioned. Oh, 38 was mentioned. I'm sorry. 39. Okay. On the prayer made by Ms. The counsel for the applicant, the matter stands adjourned today. Government is present. You're there. Mr. Counsel for the government advocate is present. What respondent is present. What is the matter about? Early appeal. Okay. Okay. Notice is served on the respondent? No. Okay, not yet moved. Okay. Yes. What is your agency saying? Okay. If you have already filed it, get it today, not tomorrow. Then get it today, not tomorrow. Why? What is the urgency? Okay, get it today, not tomorrow. Not tomorrow. Tomorrow we are not taking up any extra matters. It will be listed, but you can get it today, not tomorrow. Tomorrow I'm not burdening myself. Item 42. Okay, UFO? UFO? No, UFO, which party? Applicant or the respondent? Applicant, okay. 42. You have taken consent of the other side? You're there? You adjourn the matter? Okay. Both sides are represented on the prayer made by counsel for the applicant. Matter stands adjourned today. List after ensuing vacation. Item 39. 69. Just now. Somebody has mentioned, I will take it up. I am not upgrading it, but we'll take it up at the end of the day. We'll take it up.
Supplementary item 51 for delivery of order.
I'm sorry, there's something I missed out. Please inquire in the second half before rising. This is something I missed out. This file individually did not go to my home. By mistake, this file did not go to my home. I'll have to check it out.
Daily list item 1.
কালি কোনো পয় নাই ডেলিভারি অর্ডার থাকলে মই কব মাথা নাই Yes.
439 bail application, my lord. The error is a case, my lord, 18 months.
439, you were arrested when?
I was arrested on my lord 3/9/2023. I'm already behind the bar for 4 days. Already the my lord co-accused has been released on bail after considering his detention, my lord, 45 days. This is my lord.
What is the narcotic and what is the weight?
18 gram, my lord, and that was not, my lord, recovered from my possession. That is, my lord, my name.
Where is that? How do you say that?
My lord, my name is, my lord, only mentioned in page 19, my lord, at during, my lord, interrogation. The apprehended accused, namely Rafiqul Islam, son of Sasan Sar, admitted that he has been selling heroin for the past several months, and the is suspected to be heroin were brought from one person, namely Muhammad Ali. The main accused, my lord, Saiful Islam had already been released on bail after considering his period of detention. These are order.
Release after going to the civil or something.
Oh, this is comes the first time. This is not, it's not rejected maybe earlier. Oh, achha. Okay, then case diary. Case diary on.
Civil lordship.
This is from which place?
Not Lakshmipur lordship.
Bring it on the reopening day.
7 lordship.
So, okay, 7/11/2023. Okay. I was thinking that this, it was rejected by me earlier. Okay. Yes, item 2
Item 2,
is 22C. We have called for the case diary. Trial is going on. Okay. Which court?
Metro.
Okay. Let the scanned copy of the relevant records called for from the Court of Learned Additional District, Additional Sessions Judge number 1, Kamru Metro, Guwahati. Based on 8/11/2023.
811. 811.
8/11. Mr. S.C. Kyal, counsel, standing counsel for NCB is present.
So I will have to find my affidavit.
Okay. In the meanwhile, the respondent will file the affidavit.
Okay.
And the status you will also can bring
Yes, sir.
status of trial.
We'll include everything.
Okay. But Mr. Kyal, for some reason we were deliberating in the matter of trial of NDPS cases. A lot of judicial officers have complained against the NCB because they are not bringing up witnesses. Here it says 3 years in the trial, but on examining the this matter for some reason on the administrative side, we have found that NCB is causing a lot of delay in the bringing of witnesses. Number 1, number 2, that there are the judicial officers are complaining that most of the witnesses are repeat witnesses and they are not necessary, but for them the long time is taken. So please put on a word with your administration.
Situation has already been taken care by the office of NCB. This complaints have been already addressed by the General Director of NCB. Now we are taking necessary steps to present the witnesses before the court. Even warrant has been issued against the witnesses.
No, it's okay. I'm not on this matter. It's a general statement which I had to.
Generally, now it has not what happened. Some orders have been passed by another Supreme Court in case of delay of the trial. Taking advantage of that, trial is not proceeding. In one case, it is restricted 6 dates witnesses are present, but it was not proceeding by the.
No, for that you will be have to vigilant. You'll have to bring it on record that this is.
We are taking necessary steps. We are bringing to notice of the.
On an average, 4 years. On an average, 4 years.
No, you see, we are not blaming anyone. This is not to blame anyone. This is only to bring to notice the
Yes.
Mr. Kyal that this is an issue which is flagged and they will have to take a appropriate call. In this bail matter, I am not adjudicating on those aspects. It's only bringing to his notice. Especially when you said it 3 years. So that's fine.
Yes, it is factor.
Okay. Yes, item 4. Oh, it's a 3. 3, I missed out. Okay. Yes, Mr. Uddin.
The online frauds delegation here. So is there any purpose?
Okay. He's ready on 7/11/2023.
I would like.
Item 4.
Item 4,
And 439 bail application. Petitioner is behind the bar since 34 days. Arrested on
No, with the nature of offense, we'll have to call for the case diary. This is from which place? The Chirang,
Panbari case.
Chirang district, 811 for case diary, 811.
Outline.
Just add everywhere, case diary or scan copy thereof.
item 5,
5,
Regular related attention was
21B, and again NDPS. From which place? Khatkati, where is that? Which district? Depot, okay, 811 for case diary. 9th, okay, 9th. Okay,
6,
yes,
There is a petition under 439. Lotahil Thana PS 170. It is arrested on 7/10/2023.
batteries.
Yes.
Okay, we'll call for the case diary. Case diary on, from which place?
Lotahil.
Not a ship, okay, then 711,
item 7,
439 application. Behind the bars for 1 month, almost 1 month, arrested with 50. CT may be called for cyber PS case.
cyber PS, okay,
Cyber PS 8 of 23. It's in
okay. From which place? Mr. Goe, Guwahati, then 711,
Hold it.
8,
item 8,
Lordship, this is a 439 bail application, Lordship. Case was registered, Lordship, although Lordship, Boxo is there, Lordship, but the FIR and the Lordship forwarding report, the story narrated different story, Lordship. The girl had a relation, Lordship, through connected through Lordship, social media, Lordship. The boy came here, Lordship, from Bangalore, Lordship. Thereafter, Lordship, they are staying there for 2 months, Lordship. That time, father didn't lodge any complaint, Lordship. Subsequently,
no, but whatever be it, but since it is POXO, I have a duty to look at the case diary. This is from which place?
it's from Mongoldo, Lordship.
Mangal, then 811,
Notice will be sent to the informant, notice will be sent. Copy is there.
Yes, Lord.
okay, let the case diary be produced on 8/11/2023. Next paragraph, the petitioner shall take steps for service of notice on respondent number 2. From the registry after receipt of the process shall forward it to Miss A. Begum, learned APB, for serving it on the respondent number 2 through the jurisdictional Molde Sadar Police Station. And upon service and the service report should be forwarded by the officer in charge of Mangaldev Sadar Police Station to the learned APB for being produced before the court. 811.
You have been directed to serve the copy. to
No,
the OC.
just a moment. We'll give one more day because it is these vacations will come. 9th, not 8th, 9th.
Hurry up.
You take steps today.
item 9,
Eight related one.
Yes.
A father is framed at the behest of the mother. Page number 15 is the FIR.
No, POXO is there, will not grant without case diary. For this time, this was counsel for the petitioner and Ms. A. Begum, that is for the state. That the case diary be produced. This is from which place?
Silapathagar.
Silapathar. 10/11/2023. Here also same, the notice to respondent to petition will success.
Date was 9/11.
This is, we are giving on 10/11
10.
because it's from Arunachal.
Item 10.
Yes,
Page number 10.
just a moment. Ten.
Is 10. I finally put it page number 27.
Page.
Page 27 and it's 3. There was a proceeding under section 107 CRPC of the order is at page number 28. First and second page number 28. The last offense took place on 21st May 2023. And this petition under section 107 CRPC was made on 22nd of May 2022. Alleging that there was apprehension that the accused person was harmed to the informant side university. And in this regard, a report was also published by the concerned police station on 25th of May 2023. An FIR has been lodged on 26th of May 2023. And considering all these aspects, including the main accused, already around 12 accused has been granted bail from annexure 4 onwards, page number 31. This is accused number 306, page number 31. Apparently, accused number 306, they are the main accused. They have been granted absolute bail. Then in the next 5, you will look at page number 36. In the apparent page number 5 is one of the main accused. P5, 6 and 15, they are the main accused. And then you'll look at kind of see annexure 6, page number 41. Other accused have been granted to. Before your lordship is accused number 1, 18, 19, 20, and 21.
Grant an interim and call for the case diary. Mr. R.H. Chaudhary, counsel for the petitioners, and Ms. A. Begum, done APP for the state. By this application under section 438 CRPC, the petitioners were accused in Hailakandi PS case number so page 1, I have paid for. Here is bill. Next, having noted that the contents of the FIR dated 22/5/2023 and proceedings under section 107 CRPC before the executive magistrate Hailakandi are at some variance. In view of the projected land dispute between the two sides, the court is inclined to grant interim players bail to the petitioners, namely so and so, providing that in the event of their arrest in connection with aforementioned case, they shall be released on bail on furnishing bail bond of rupees 20,000 each. Oh, sorry, 30,000 each with one solvent surety of like amount to the satisfaction of the arresting officer. So along with the bail bond, the petitioner shall submit an undertaking that they would be prepared to surrender before the police in the event this application is dismissed after perusal of the case diary. The case diary or scan copy? Case diary on
14/11.
14/11/2020. We'll make it 15/11/2023. You have to give an undertaking that you will surrender if it is dismissed.
Supply item 53.
The bill matters are over.
There is one bail hearing and 3 orders in.
We'll take it up. I think we'll free you. We'll take up bail matters if the lawyers are present. Which items, Ms. Begum?
Lordship, in orders, Lordship, there are item number 26 and 27, Lordship.
26, 27, councillor present. They're not there. You can come at 2 o'clock. We'll take it up at 2.
Item number 2.
Mark will look. Mark it in your cost list.
It is on 53.
53. Yes.
Case regarding passport case. The judge.
Okay, what is the ground?
Ground is from test to CS. Number 1, because she is residing at parents' house at the and
Okay. Okay. Mr. Anand Upadhyay, counsel for the petitioner. Next, by this application under section 24 CRPC, the petitioner is the estranged wife of the respondent is seeking transfer of matrimonial proceedings of FC Civil page 1 from the court of Principal Judge Family Court number 2 Kamru Metro Guwahati to the court of Learned District Judge Sonitpur Tejpur on the ground that the petitioner is residing in a parental home at Tejpur. Next one, issue notice returnable on so you give a fixed date. Petitioner shall take steps in course of the day for service of notice of the respondent by registered post with AD. Next, till the next returnable date for the proceedings of so and so shall remain state. The petitioner shall produce a certified copy of the order before the learned court to bring the order to the notice of this head learned court. List answer as well.
6/12/23.
54. Yes, Mrs. Ha.
After revision, I can notify the.
Where is your injunction application?
Yes, sir. Okay. One 26.
Injunction application, where is that?
126. The trial court, your lordship, I have also had an injunction application before that rate. And this injunction application is at page 156. Appellate court, the injunction application which I have.
No, trial court, trial court.
The lordship, 126.
Page
Page 150.
120.
And accept. In this case, I am the owner, I have filed the documentation. My name is there, also there in the government.
112 is the suit.
126.
26. Okay.
I could have issued notice.
Where is some photograph showing that they are carrying on construction?
Dear Lord. Proceed 90, is 90,
Page
90, 90.
19.
Next thing. Then the boundary wall there.
Where is the plaintiff, 10, TS 10 of 2023,
Your lordship, page 83.
83?
It was filed only on the basis that I have gone for demarcation of the land, and if it is demarcated, then I will say.
Heard Mr. Anand Jha, counsel for the petitioner. Next paragraph. This revision under article under Mr. Jha, under 227, we can't do anything. We don't get the original jurisdiction.
I have.
227, we can't give an injunction under 227.
And what is also your lordship, because I can, your lordship, against the first order in injunction. Injunction is still pending. So I cannot go on 115, your lordship.
Why?
It is not finally disposed of. At the interim stage, your lordship, I am with your lordship.
No, against the refusal of injunction by the first appellate court, 115 will not lie.
But it is the first, it is not disposed of your lordship finally. Lordship,
No, but under 227,
171, your lordship.
but under 227, we want the power to give.
Your lordship, protection may be granted your lordship because they are prospective.
In 227, will not be able to give you any. It will not be a extension of the suit. Therefore, no injunction.
It's, your lordship can exercise one before your lordship.
No, because you see, I have my doubts. We'll take it up 2 o'clock. Let me examine the law.
Hello.
227 to grant an injunction at 2 o'clock. Let me consider. Item 12.
Yesterday, your lordship passed, if you notice, only the money execution case number is different.
Case number is different. Okay. Yesterday, that was item number yesterday.
I can know 4 and 5.
Item number 4 and 5. Same
RFA
order.
42 of 2020.
RFA 42. Okay, same order. Okay. Okay, same lawyer. Mr. D. Goswami. 13.
Item 13. Item 13,
Yes, MFA, review appeal. Appeal under non-refusal call for the appellant. Appeal under Section 23 of the Railway Claims Tribunal Act against judgment and ordinated page 1. Appeal is admitted for hearing. Call for the records. The applicant shall take steps within 2 days for service of notice on the respondent by serving additional copy of this memo of will to the learned to the office of the DSGI. This after 4 weeks. (14)
Because there is a comma, and made an exclusion.
Deposit 50%.
You were the order passed by this honorable court whereby 75% was deposited in some other case. So think it has
No,
same
no,
very
not
quickly.
that will you file an application will consider not more than 50%. But today, even for that, we do not have time. So consider your prayer, make an examination. Correct. Some other day, you make a prayer, we'll consider. I will record in the order sheet. You will be permitted to make that prayer on the next date.
Yes.
MEC appeal. Mr. S.K. Goswami. For the appellant and Mr. A. Kakoti, counsel for the respondent number 1.
1 to 5.
1 to 5, okay.
Inadvertently recorded the 1 to 5.
It's okay. 1 to 5. Page 1. Call for the records. Notice on respondent number 6 and 7 by registered post with AD. List after 4 weeks in the IA. Stay subject to deposit of 50% of the awarded sum before the registry of the court within a period of 6 weeks. So on such deposit being made, the registry shall permit the respondent numbers 1 to 5 to withdraw the awarded sum on being satisfied with the as regards their identity. Next para. On the prayer made by learned counsel for the respondent numbers 1 to 5 is permitted to renew the prayer for directing the applicant to make further deposit on a deposit of further amount of the award on the next date.
Only my prayer can redeem this. Subject to bond, because you don't have to keep the bond. As part of the offense.
Pardon me?
Because it is a private thing, because you're crediting an account, it is a commercial thing. So owner has to give the bond extra. The cabinet discourse has followed that owner has to give
No, he's the claimant.
payment.
Claimant will not be required to give a bond.
Owner has to give a bond.
Owner will have to be given. Because you are challenging the, you are shifting the liability on the owner. Okay. And as on the prayer made by learned counsel for the applicant is permitted to renew the prayer for directing the respondent number 6 or owner of the vehicle to furnish a bond on their appearance. The said prayer may be renewed on appearance. This after 4 weeks. 15.
main আৰু আই দুইটাই
Notice.
For enhancement of compensation.
Enhancement. Okay. Enhancement of Mr. M. Talukdar for the appellant and Mr. R. Goswami for the respondent number. Respondent number. Respondent number 2. A bit for announcement. Notice for,
Respondent number one has already been struck out. Respondent number one has already been struck out.
who is responsible? One
One is the owner.
has been struck off.
So can you see ISC bill number 12820?
No, when you're saying you'll accept it. Before that, you write the learned counsel for the applicant has applicant has submitted that by virtue of the order passed in connected IS Civil 1088 of 2020, the name of respondent number one has been struck off. Resultantly, the name of respondent number one shall be struck off from this memo. Then no need of issue notice. Under the admin call for the records, the start of office awaiting LCR. Sixteen.
Current finding. About, having said I prepared draft substitution of law. Plaintiff claim is that he has purchased this fruit land from the pro forma defendant number 2 and 3 in the year 1997 by registered sale. And
From respondent number,
2 and 3.
yes,
And I have been exposed them.
you are the plaintiff or defendant.
I'm dependent. I have been disposed them from one kathas of the said purchase land. So they have filed this suit.
Yes,
And our case is that I have purchased, that is my predecessor, my father, my name was purchased in the year 1977. But
pardon me,
I have purchased
77, 97 you said.
77. And plaintiff's claim is they have purchased in 1997.
Same year,
No, I am 77.
you are 77.
77.
Plaintiff in 1997.
97. That sale deed was exhibited as exhibit 2. And my sale deed was exhibited as exhibit 4. Our another
From your written statement, show your schedule.
our case is that when the father of the respondent number 2 and 3 sold it out this state land, inadvertently in the sale deed, dark number and patta number has been wrongly mentioned.
In whose cell lead? Your cell lead.
Myself.
Yes.
And on the basis of this awardment, both the court below going through the evidence only with respect to the defendant's case and dismiss this suit, decreed this suit on the ground that the DUG number and patta number is different. So this land which has purchased by the plaintiff
that is not the exact same land. This is the case. But without going into the boundaries of the both the cell.
No, you see, if the CLD is not correct, you would have to file a suit for what you call for rectification of the deed that was not done.
Not done.
So if you have an incorrect title deed with you, it doesn't confer any title.
But the boundary of that cell deed is the same. So all these things has not been gone into by the both the court below.
No, you see, very difficult to accept it.
And this is the finding of both the court below that we are in possession of the plan. That is the defendant.
No, you see, you have CPC. Give CPC to. Oh, you have CPC? I'll give it. Have direct. You see, Order 7 Rule 3, the plain shall contain description of boundaries sufficient to identify it in case property can be identified by boundaries or numbers in a record of so and so. So it is both. If it can't be found out from the survey numbers, then from the boundary. But here the survey numbers are available. So it is the option of the court, unless you can show that.
That has not been done into. Only on
No,
the
your
basis of-
pleadings, it is your pleadings and evidence from which you will have to put
I-
forth
I'm
that
the
case.
defendant. I'm the defendant.
No, it's part of your defense. You'll have to take it that this is the correct description.
I have taken that.
Where is that? Because you see, come to page 14.
Page 14.
In 14, this is, no, this is your written statement.
Yes, fine.
5 lines from the bottom.
Yes.
Let us see from 6 lines. Thus, it is clear that defendant's vendor so and so had sold the defendant patta number so and so on receipt of proper consideration. He had fraudulently mentioned the land of another dag of so and so. So you've taken a plea of fraud.
Fraudulently mentioned the tag number, another tag patta in the schedule of the deed. However, he handed over possession. This is important. However, he has handed over the possession of patta number 47, which the defendant has been enjoying possession uninterruptedly and with the full knowledge of the original owner
So-
since 1977. So, father of the respondent number 2 and 3 told.
Who is your vendor?
My vendor is that is Yogendranath Goswami.
So he is not examined as your witness.
Yogendranath Goswami died.
No, but his legal, somebody will see
Yes, the respondent number 2 and 3.
respond number 2 and 3.
Is the legal, yeah.
They are the plaintiffs.
No, they are the pro forma defendant. Plaintiff is from whom this pro forma respondent.
Just 2 and 3.
2 and 3. Pro forma defendant numbers 2 and 3.
Jatin Goswami and Labani Mohanto.
Shiva Prasad Goswami and Jatin Goswami.
Okay, 1 and 2.
That is pro forma defendant number 1 and 2. These two sons sold the same land to Manudati. That is to Shivamangal, that is to the place. And their father sold it to me.
How did the trial court deal with the issues?
Nothing. Trial court has both the court below. Only said that in the sale deed, there is a wrong dag number, patta number, So this land is not the same land. Trial court finding LDC at page 22, my lord. Issue number 2 and 3. The instant case plaintiff claimed that he has dispossessed from 1 kathas of total mentioned in schedule. I have purchased more than 1 katha. Remaining land is under his possession. Remaining land is under his possession. On the other hand, defendant claimed that the entire suit land is in his possession. The defendant in his evidence stated that vendor of and the owner of the Jagendra Goswami had in fact sold land of PP number so and so of DAG number 307, though same was inadvertently sold the land of PP number 67 of DAG number 97 in the sale deed. As because the vendor has delivered the possession of the suit land covered by PP number 47, DAG number 307, and not covered by DAG number 97, PP number so and so, that since 12/1/77. He was in uninterrupted possession of the suit land for 35 years to the knowledge of the true owner and his heirs on his own right. The defendant further claimed that after selling the suit land, the pro forma defendants did not have any valid right and title to sell the suit land in favor of the plaintiff. The plea that owner vendor Jagendranath Goswami has in fact sold the suit land of PP number so and so, and in the sale deed, the land was inadvertently sold as DAG number 67 of DAG number 97. It is correctly pleaded case of the defendants as according to the pleaded case of the defendant that the vendor has sold the suit land and has fraudulently executed a deed showing that he has sold land covered by PP number so and so by deed number so and so. Hence, considering the above evidence of the defendant, DW1 that the suit land was wrongly mentioned in the sale deed number so and so as that of the covered of the number so and so, which has been executed cannot be accepted. Only
You just say everything is going against you. When you take a plea of fraud, that is was something you will have to establish. You are referring to this, what you call this, section 48, that was not introduced in the trial court. In the grounds of appeal before the first appellate court, also that is not the ground.
But my all along claim is that I have prior purchase.
But you see, if the DAG number is in variance, the land which is purchased has to be the title deed has to be what you call. You could have filed a what you call a cross suit, not a counter claim, but a separate suit for rectification of the deed. That was not done. So your title will not be established.
My lord, both the deed are before this honorable court. And the main question is whether this land which I have purchased and whether they are land or similar land or not.
That was then exercise to be done before the trial court or the first appellate court. You see, now we can't have a commission to examine as a
But
question of law.
Both the people have not gone into that aspect.
It was never raised. You look at the issues, you face the trial without those issues. Appellate court also, the ground of appeal, page 40, it's not there. In the second appeal, we can't create a new case.
So there is not a new case. My claim is that I am prior purchaser. He has no right to sell it out to the defendant.
But if there's a mismatch, you have any authority to the point that even if there is a mismatch, that would not be fatal for the person claiming title.
Now, mismatch, if there is a drug number and partner number in mismatch, then boundary will prevail. Boundary of both the deed are before the courts below. It is not that I have not exhibited that document. I have withheld that document.
If there is a dispute, then you'll have to have that exhibited through the vendor or his legatee.
I have exhibited that.
No.
They have also exhibited that.
This your vendor has not come to dock and admitted.
Right.
No. You see, vendor means his legal heir also steps into that shoes. He also did not come to depose that yes, there is a mistake in the creation. Boundaries will be relevant, say, in an ejectment suit, when there is a misdescription of the boundary. Then we can take into consideration that that error. And say that the boundary which is existing will prevail, but to have a sale deed ratified on the ground that it is matching with the boundary and therefore error of survey numbers is not a substantial defect. That is something we can't decide in the second appeal.
Here in this case, my lord, my
No, your case, I'm not saying absolutely, I'm not discarding that you don't have a case, but you see, for a second appeal to have that adjudicated, something which we can't assume jurisdiction. You see, in the trial court, if it is wrongly decided, then we can say it's a issue for the second appeal. But when in the trial court itself,
my lord, it is the plaintiff's case, they have come up with a title deed. They will have to prove that this land, when he has purchased, from whom they have purchased, they have the valid title. That part has not been discussed by both the court below. Even not a single sentence has been said about that the plaintiff has acquired title from the vendor. That is from Prohuma, number 1.
his title was never questioned.
Title was questioned. I have questioned because title, that is why he has filed the suit for declaration of right.
Sure, sir, written statement doesn't show that. You have raised a plea of fraud. That's what I'm referring to at page 14. You raise an issue of fraud.
Kindly see the claim, my lord. The plaintiff in respect of scheduled for land, he declared that the plaintiff is in possession in respect of scheduled for land within the scheduled law. He confirmed. Defendant be evicted land of scheduled for land and plaintiff be awarded first possession of the land of schedule. The permanent injunction be issued against the principal defendant, thereby preventing causing so and so. They have kindly see page 9. First, there is plaintiff's title. Now, when we see the judgment of the landed trial court, there is not a single sentence has been apart that the plaintiff acquired title. Valid title. And I have examined Shiva Prasad Goswami. Oh, sorry, they have examined Shiva Prasad Goswami. The plaintiff have examined Shiva Prasad.
You have the evidence of Shiva Prasad Goswami. Shiva Prasad Goswami is your vendor's son.
Understand? One son. Another son was lunatic. So this cell deed was.
No, he's not lunatic. He has speech disability.
Yes, disabled.
Uh,
Disabled.
You have a copy of the evidence of PW2?
But kindly see page 32.
Just one. Forty-two.
First line. Cell deed exhibit 2 was executed. One of the vendor, Jyotin Goswami, was unsound mind. And so the said deed is illegal and void.
40,
42.
which line?
First line. Is our submission before the learned bar is yes, record learned transport so allow the pro forma defendant to be represented by the elder brother pro forma defendant for one. Moreover, no relief is claimed by the plaintiff against the pro forma defendant.
No, somewhere else it is speech disability.
In trial court.
Trial court says, somewhere I have seen, I don't remember where, but
But here, this our submission that he was unsound mind and he was represented by the.
unsigned mount, it becomes a issue regarding character that can't be proved like that.
But he was represented by pro forma defendant.
No, that may have been, but we can't take cognizance of that. The Mental Health Act and the mental, what you call, the new act, Disability Act, doesn't permit the court to take cognizance of mere statement that somebody is of unsound mind. In the earlier Mental Health Act, it was the civil surgeon who had to give that certificate. Now it is an institution of special care. So merely by saying that he is of unsound mind.
My lord, can you see page 42? Last.
Just a moment.
From last
I am just
paragraph
finding
to
out
second
where I have read this, that is speech disability.
Defendant number 1. Shiva Prasad Goswami adduced evidence as PW2 and admitted the execution of cell deed.
Just a moment. Yes, you come to page 20.
Lord, assuming he is not unsound mind.
No, you see page 20.
Then
The court has given a fact finding.
yes.
He says that the pro forma defendant number 2 was called directly to appear. He appeared. On his appearance, pro forma defendant number 2 was found to be a person who could not speak.
Yes.
And the court found him to be physically disabled on that count. And while order dated so and so, he allowed pro forma defendant 1 to continue representing pro forma defendant number 2.
Now kindly see page 42.
42.
From second, last. Second. Pro forma,
That is your plea.
no,
The plea taken by defendant in written statement.
no, before that, pro forma defendant number 1, Sri Shiva Prasad Goswami adduced evidence as PW2 and admitted the execution of sale deed number so and so by him and his brother pro forma defendant number 2. So if he was not of unsound mind, whether on the basis of that sale deed, right can be conferred. Suppose my brother.
No, in second appeal will not answer that.
No, it was the first question.
No,
that-
you see that question of title to be extinguished is that finding of fact unless you raise it there.
No, it was the first finding that on the basis of this sale deed, they have not acquired because they have not really title at that point of time. And they are claiming that they have purchased it from the pro forma defendant number 1 and 2, though 2 has not executed this. 2 has not executed. It is only 1 has have executed.
Please read that part again. Pro forma defendant number 1, Shiva Prasad Goswami,
Yes.
adduced evidence as PW2
And it-
and admitted the execution of the sale deed number so and so, exhibit 2 by him and his brother.
and his brother pro forma defendant number 2 in favor of plaintiff.
So it doesn't say that I signed on his behalf.
He confirmed his signature of exhibit 2, 1 to 4. Plaintiff has proved his title over the suit land.
So it doesn't say that he signed. And even if you assume that the brother signed on behalf of the other brother, I'll show you something. I'm always citing this. Black's law dictionary. You see, in my courtroom, I always give an example. I may be repeating it before you, but this is something I have repeated many times. I've repeated it many times. You see, today, I have a very busy schedule. At 1 o'clock, instead of having my lunch, I'll be attending a meeting. At 4:30, again, there is a meeting. And by the time I am free with all this, it may take me about 7 o'clock, by which I am settled to sign all the orders. And therefore, 2 or 3 orders where I have adjourned the matter, list on so and so. I have asked my court masters to sign it. So he will sign in my name. Now look at the second flag in the dictionary. Second flag, down below. Second flag, flag number 2. Second flag, definition of signature. 1057, right side page. Yes, signature. Please read that.
A person or entity that signed a document personally or through an agent and thereby became a party to an agreement. 8 countries are
No, signature.
signature. Yes. Signatory. Signature. A person's name or mark written by that person or the person's direction, also terms sign amendment.
Correct. So a person himself giving a mark, or at his direction if it is a mark is given. So therefore, technically, if I ask my court master to give a mark and send it, it becomes a valid order until and unless I say that I have not signed it. So under this definition of signature in Black's Law Dictionary, it is permissible for one to sign on others' behalf if he has an authority. I'm not saying it, this is Black's law. And Strouds will also have the same thing. I also have Strouds at my home.
But here in this case, it is it's slightly.
No, not that. I'm just,
Because they have acquired title to their.
no, that's okay. That's
Other.
what I'm saying. You see, unless there's a document which is questioned and annulled by a court, the title will flow from it.
Not that termination is required. Whether they have acquired title on the basis of that document. or
That is a finding of fact. It has been
not.
returned.
That has not been discussed.
Yes, it has been.
It has
I won't-
not been discussed.
I-
He said that he has purchased it, so it is acquired title.
Because
And
nobody,
our
you see,
case is
vendor
that-
comes and says that he has sold. So therefore title will flow from it. Who has questioned it? You see, let us say somebody questions. Let us say there's a person A. He is a matriculate. And somebody questions that, no, he is not a matriculate.
My lord, I have purchased from their father.
No, you see, we are discussing on the issues. In a second appeal, you know,
On the part of the pro forma defendant number 1 and 2, even if my father was wrongly written, suppose the number, patta number has been wrongly mentioned, but the boundary which I have is in possession, on the basis of that, they have also pious obligation to correct the deed. Suppose,
Morality.
because they are not moral, they are not claiming that they are not saying that they have not, their father has not sold it out the land to me.
I don't know, but there is a finding. You don't find a substantial question of law involved here. There is a finding of fact, we can't reverse it here unless there is a substantial question of law. If that evidence is not there, you suffer the consequences. Because you have not filed a counterclaim to assert your title. It's only a defense taken and that defense has been established. I have found that. Sorry, I was reading it. Just give me 1 minute. This is something we read on the last day when it was listed. Yes, at page 24. First paragraph, about last 6 lines. Out of the 2 vendors of Exhibit 2, who is the pro forma defendant number 1 and 2, pro forma defendant 1 has also adduced evidence regarding execution of Exhibit 2 in favor of plaintiff by him and his brother pro forma defendant number 2. As such, I am of the measured view that the plaintiff has been able to establish his title. So once the title deed is proved, you can't say that the title was not proved. Question, although we are not finding it, dismissing it. But Mr. S.K. Ghosh, learned counsel for the appellant. Next, this appeal under section 100 CPC is has been filed to assail the appellate judgment and decree dated 9/9/2015, passed by the learned civil judge Nagaon, entitled appeal number 12 of 2013, page 1, dismissing the appeal and affirming the judgment and decree dated 19/1/2013, passed by the learned Monsif Kaliabor in TS number 16 within bracket K of 2007, by which the suit of the respondent number 1 was decreed. Next paragraph. The learned counsel for the appellant has referred to the substantial question of law, a draft substantial question of law contained in the memo of appeal, and has submitted that he has prepared a recasted substantial question of law and placed for admission of the appeal on the said substantial questions of separate page. Next paragraph. The respondent number 1 is the plaintiff in TS 16K of 2007, wherein the appellant is the respondent number 1. First of the vendors in respect of the sale deed executed in favor of the respondent number 1 were arrayed as pro forma defendant numbers 1 and 2. Who is this 3? The plate does not contain any statement with regard to the pro forma respondent number 3. Next, the case of the respondent number 1 plaintiff is that he had purchased 1 bigha 3 kata land from the pro forma respondent numbers 1 and 2 out of their total land measuring 2 bigha 1 kata covered by the Act number 307 of periodic patta number 47 at Rangalu, RANGALU, Kisamat KISSAMAT under Dwar Bagori, DWARBAGARI, Moza, in the district of Nagaon, on a valuable consideration of rupees 12,000. Full stop. No, not full stop, comma, by registered sale deed number 86 of 97. It is claimed that they were put into that he was put into possession of the suit land, and his name was also mutated in respect of the purchased land. Full stop. It was claimed that the respondent number 1 tried to forcibly occupy the suit land, and accordingly a proceeding under section 145 CRPC was drawn up at the instance of the respondent number 1 against the son of the appellant. First, it is claimed that the appellant had forcibly occupied 1 bigha 1 kata of out of the suit land on 2010-2005. Full stop. Accordingly, the suit was filed for declaring the right of the plaintiff, title of the plaintiff in respect of the respondent plaintiff in respect of the scheduled land is co-scheduled land, co-scheduled land.
I have proceeded to buy one cut, schedule ball.
No, I'm writing the plaintiff's case.
Yes.
I don't know, at page 8, it is written 1 Vigha 1 Kata.
And page 9 tells here, page 4 is the first position. One cut within schedule column. One here, two.
Page
Page 9.
where schedule,
There,
which prayer,
page 9.
which
Defendant be evicted from the land of schedule co and co, and the plaintiff be awarded first possession of the land of schedule co land.
no, that's okay, I'll come to it. We will note it because right now I'm in the text of the plaint. That doesn't say about 1 Kata. Okay, accordingly, that is prayer number co. Don't say co, prayer, semicolon. The respondent number 1 also prayed for his for confirmation of his possession over the land described in Schedule Co within Schedule Co land, semicolon, for eviction of the respondent number 1 from the land described in Schedule Co and Co and claimed first possession of the land described in Schedule Go. First, it may be mentioned that Schedule Go of the plaint relates to 1 Kata land within Schedule Co, excluding land of Schedule Co, PHA. The respondent 1 had also prayed for permanent injunction. Full stop. The Schedule Co land is as follows, page 9. And Schedule Go from which eviction was sought for against the appellant is described below. Schedule Go at page 10. First one. Next paragraph, the appellant as defendant number 1 filed the written statement and along with usual plea, it was the stand of the appellant that the suit was barred under section 64 and 65 of the Limitation Act. As well as section 27 and 28 of the Limitation Act. Full stop. It was also claimed while denying the claim of the respondent number 1 plaintiff, the
Paragraph 19, page 5.
so it was claimed that the land mentioned in paragraph 1 of the plaint And that in Schedule Q and Schedule Q are all different. And that the respondent one had paid for decree in respect of the land which is less than the land in respect of which he had paid for relief. First, it was also stated that out of the total land measuring 2 bigha 1 katha covered by DAG number 307 of periodic patta number 47, the applicant was enjoying possession of 1 bigha 3 katha land by including the same in a plot of land measuring 2 bigha 1 katha, which he had purchased in the year 1977 from Jogendra Goswami. Spelling is Jogendra is correct or incorrect here? Page 14. Jogendra Goswami. So it is claimed that the father of the appellant had purchased land in the name of his son, Bal Bahadur, B-A-L Bahadur. And that Mano, M-A-N-O, Darji, D-A-R-J-E-E, is also known as Bal Bahadur. And that the purchase was made in the year 1977 by deed number 646. Wherein the sold land was referred to as 2 bigha 2 katha 11 lacha land covered by DAG number 97 of KP Patta number 67 at Rangalu, R-A-N-G-A-L-U, Kisamat, K-I-S-S-A-M-A-T, under Chotial, C-H-A-T-I-A-L, Moza. Which was a fraud committed on his father. And then the appellant was given possession of 2 bigha 1 katha land of DAG number 307 of Patta number 47, which the appellant has been enjoying since 1977. Next one. It was further claimed that Jogendranath Goswami and another, who are the son of Brajanath Goswami, were the owners of 2 bigha 2 katha 11 lacha land in DAG number 97 of Patta number 67. And that the appellant had not purchased any land from any land under Patta number 67 from Jogendranath Goswami. And the name of the appellant's sale deed, the name of father of the vendor, Jogendranath Goswami, is mentioned as Purnadev, Purnadev Goswami. According to his claim that the owner of the land of Pata number 47 was Jogendranath Goswami, son of Purnadev, Purnadev Goswami, whose successors in interest are pro forma defendant numbers 1, 2, and 3. So Varanga explained that the appellant's vendor, i.e. Jogendranath Goswami, son of Purnadev Goswami, right? Purnadev Goswami had sold land to the appellant under Pata number 47, but another Dag and Pata were fraudulently mentioned in the sale deed. Nonetheless, the appellant has been enjoying possession of the said land uninterruptedly since 1977. According is the case of the appellant is that as the land was sold to the sold to him in 1977, there was no right to sell the same land to the respondent number 1, and therefore it was claimed that the suit was liable to be dismissed. Full stop. In course of trial, the following issues were framed. Page 25, 6 issues. In support of his case, the respondent number 1, plaintiff, had examined 3 witnesses, page 26, and exhibited the following documents. The appellant, defendant number 1, had examined 3 witnesses and exhibited the following documents. That's same page 26. Full stop. In respect of issue number 1, the learned trial court found that there was a cause of action for the suit. In respect of issue number 2, it was held that the suit was maintainable. However, it appears that the learned trial court had committed an error in respect of his decision on the issue number 2. As it has been mentioned, in respect of the said decision, that the issue is decided in the negative. In respect of issue numbers 3 and 4, this was taken up together, but incorrectly mentioned in the heading as issue numbers 2 and 3. The learned trial court had examined the evidence on record and referred to the evidence of the appellant that although he was sold land covered by periodic pata number 47, dag number 307, it was inadvertently referred to as periodic pata number 67 and dag number 97 in the sale deed. And accordingly, the sale deed of the appellant within bracket exhibit co being sale deed number 46 of 77 was not found acceptable. We also held that the appellant's plea that the vendor of exhibit co had practiced fraud upon his father could not be established. It was further held that the appellant had expressed his ignorance about the dag number and pata number of the land sold by respondent numbers sorry, perform respondent numbers 2 and 3. To the respondent number 1. List of the evidence of the DW 2 and 3. Were not found reliable. And in this regard, it was held that the DW 1 and 2. Failed to withstand the cross-examination and could not state the facts which they had asserted in the evidence on affidavit. Full stop. In respect of DW2, it was held that the said witness admitted in his cross-examination that he did not know as to what was written in his evidence on affidavit, and that he also did not know who had sold the land. And he had only heard that the same was purchased by the appellant and could not say the dag number and pata number of the suit land. The DW3 was also not a witness to the execution of the sale deed and did not know the dag number and pata number of the disputed land. Full stop. The evidence of the appellant was not found reliable as because of his failure to examine the two attesting witnesses of the sale deed. And it was held that the evidence of the appellant was not convincing to establish his pleaded case that the vendor had fraudulently mentioned another dag in the sale deed. So it was further held that even after the discrepancy of the sale deed came to his notice, the appellant could not demonstrate that he continued to remain in hostile possession of the suit land for a period of more than 12 years to extinguish the title of the vendors, i.e. perform respond number 2 and 3. So perform respond number 2, not 3. To the effect that the vendor did not have subsisting right and title over the suit land, so as to transfer the same to the respond number 1. It was held that the respond number 1 had proved his title over the suit land by sale deed within bracket exhibit 2, Jamabandi within bracket exhibit 1, showing that the name of the respond number 1 was entered as a patadar. And more so because there was no dispute that the original owner of the suit land was the respondent number 2. Sorry, the father of respondent number 1 and 2. Accordingly, the issue number 3 and 4 was decided against the appellant by holding that the suit was not barred by adverse position or under the principles of waiver, estoppel, and acquiescence. Resultantly, in view of the finding recorded in the other issues, in respect of issue number 5, the respondent number 1 was found entitled to a declaration and decree for eviction of the appellant from the scheduled call and next paragraph. Appeal was preferred against the judgment and decree passed by the trial court. Upon hearing the learned counsel for the appealing parties, the learned first appellate court formulated a point of determination as to whether the impugned judgment and decree appealed against is sustainable in law. I'll take a break and come back. You just wait. There's a request made by the respondent in person to the prayer for adjournment. It's better the learned first appellate court had revisited all the issues in respect of and the finding of the learned trial court on issue number 1 was affirmed. Full stop. The objection is to the mental impurity suit was examined by referring to the provisions of Order 32, Rule Rule 15 CPC. And in the said connection, it was held that the trial court, by order dated 7/1/2012, allowed the pro forma respondent number 2 to be represented by his elder brother, the pro forma respondent number. Sorry, here it will be 3 by respondent pro forma respondent number 2. And moreover, no relief was claimed against the pro forma respondents, and therefore the issue was decided in the affirmative and in favor of the respondent plaintiff, respondent number 1 plaintiff. Full stop. So in respect of issue number 4, the learned first appellate court had held that the appellant could not prove that his vendor had practiced fraud upon his father. That his father's vendor had committed fraud on his father. And that the appellant had not approached the vendor for correction of the dag number and button number in the sale deed. And that no deed of rectification was executed by the vendors. Was done accordingly on the basis of Exhibit 2. It was held that the respondent had been able to prove the title. And on the other hand, having regard to the sale deed of the appellant within bracket exhibit co, comma, the plea that there was a fraudulent error in the boundaries of in the dag and pata number of the suit land. It was held that the appellant had failed to prove that the suit land which was purchased by exhibit co sorry, the suit land and the land purchased by exhibit co were within the same boundary. And accordingly, it was held that the said issue was rightly decided by the learned appellate court. Recently, the issues number 5 and 6 were also decided against the appellant. And the appeal was dismissed on contest. At page 44, I have to make a after issue number 2. You see, although in respect of issue number 3, it was held that the appellant had failed to prove the claim of adverse position. Therefore, the said issue was also decided in the negative. And it will come in 3. Next paragraph. In respect of the draft substantial question of law number 1, which is urged by the learned counsel for the appellant, it was submitted that the sale deed of the appellant was of the year 1977, whereas the respondent number 1 claimed to have purchased this suit land in the year 1997. So accordingly, it is submitted that the prior rights which was created in respect of the land sold to the father of the appellant, those rights would have a priority over the rights, if any, flowing from the subsequent sale deed. First off, it is also submitted that all along it was the case of the appellant that, notwithstanding the description of land contained in the sale deed, the appellants, the father of the appellant was put into position of this 47 is too big a one katha, Mr. Ghosh, that he is in occupation of they were put into, his father was put into position of 2 bigha 1 katha land covered by dag number 307 of Pata number 47. It is in this context, it is submitted that in the event there was a discrepancy with regard to the dag number and Pata number of the land, it would be the boundary that would prevail. So accordingly, submitted that both the courts below had heard on facts and in law in declaring the suit and discarding the discarding exhibit the sale deed of the predecessor in interest of the appellant.
The deed of the appellant.
Pardon me?
The deed of appellant.
No, you say that you are also holding land in dag number 47.
I have purchased, then I have purchased, position of 47.
That's what I am saying.
I have in my name. The deed was in my name.
Oh, I am sorry. Not predecessor in interest of the father, the appellant's sale deed. Okay. In the said context, comment is submitted that in view of the plea taken by the appellant in the written statement, the burden, it was the burden of proof on the respondent one to prove that he had got a lawful title. In the said context, it is also submitted that it was the finding by the learned first appellate court that the pro forma respondent number 2, who is the vendor of the respondent number 1, was of unsound mind. So accordingly, we submitted that a valid title could not have flown or could not have passed on to the appellant, respondent number 1. Anything I've left out in your plea? No, there's one point you asked, I have not referred it. One of the submissions I forgot to record, I'm not recollecting it. What is that? First was the illness of the pro forma defendant number 2. Then the plea that the boundaries are same.
Regarding section 48 of the PCA. It was
48 I have referred.
101 of
101 I have referred. The evidence, burden of proof, I have said. Covered. Okay.
one is pious obligation.
Oh, it is also submitted that as it had admittedly come out in the evidence of the appellant, that there was an error, that an error was committed in executing the sale deed. Within bracket exhibit co, wherein the incorrect document had been referred. So it was submitted that it was a pious obligation of the vendor to rectify the sale deed. Next paragraph. At the outset, it may be mentioned that the parties had contested the suit on the basis of issues that was framed before the learned trial court. Full stop. In the course of trial, no attempt was made to introduce any fresh issues for adjudication. Full stop. When the matter was taken up in the first appeal, again there was no attempt to draw the attention of the learned first appellate court to formulate any fresh point of determination and to hear the parties of the same. Full stop. On a perusal of the memo of appeal before the learned first appellate court, it does not appear that with clarity it was pointed out as a ground of appeal that the right of the prior transferor would prevail over the subsequent sale deed. Full stop. Therefore, in the considered opinion of the court, no substantial question of law would arise when a plea is raised for the first time before the second appellate court on the point. Full stop. Nonetheless, on examining the issues which have already been decided, specifically with regard to issue number 4, the court finds that it is not in dispute that the admitted case of the appellant is that the incorrect dark number was inserted fraudulently in exhibit co. Full stop. The learned first appellate court had rightly held that the appellant did not exercise right to have the cell deed rectified. Said cell deed rectified. Full stop. Although a plea has been taken that when there is a dispute with regard to the dark number and the boundary, comma, it will be the boundary which prevails. Comma, but the fact remains that in terms of the provisions of Rule 3 of Order 7 CPC, comma, the requirement of the said provision is that where the subject matter of the suit is immovable property, comma, the plaint shall contain a description of property sufficient to identify it, and in case such property can be identified by boundaries or numbers in a record of settlement or survey, the plaint shall specify such boundaries or numbers. Full stop. The respondent plaintiff had given a schedule call of the plaint describing the dark number, pata number, and the boundary of the cell on the suit land. Full stop. At that point of time, comma, it was required of the appellant to approach the competent court having jurisdiction for the rectification of the sale deed. Full stop. From the discussions of the evidence of the witnesses made by the learned trial court as well as the learned first appellate court, it could not be found that a specific evidence was led on the point that the boundaries shall prevail when there was an error in the cell deed with regard to the dark number and pata number. Full stop. In the considered opinion of the court, comma, if the survey numbers or dark number and pata number are different in the sale deed, and the purchaser occupies a different part of the land, comma, his right title and interest cannot be fructified on a land which is being occupied if it is not within the concerned dark number and pata number. Therefore, the court does not find that the plea taken for the first time in the second appellate stage regarding priority of rights as provided under Section 48 of the Transfer of Property Act could be taken up for adjudication as a substantial question of law. Full stop. The second point raised by the learned counsel for the appellant is the application of section 101 of the Evidence Act. Full stop. In this connection, the learned trial court as well as the learned first appellate court had returned a definite finding on issue number 4 that the respondent number 1 could prove his right title interest over the suit land. Full stop. In this regard, the learned trial court as well as the learned first appellate court relied on the evidence of PW2, who was one of the vendors of the sale deed within packet exhibit 2, who had admitted execution of the sale deed in favor of the respondent number 1. First of all, although the appellant is taking a plea that the performer respondent number 3 was a person of unsound mind. The court is of the view that it could not be proved that the respondent number 2, sorry, not respondent number 3, was a person of unsound mind. In this regard, we may refer to the observations made by the learned trial court in the beyond judgment, wherein it has been recorded as follows: inverted commas, page 20, last part. Page 20, last one. Right. Therefore, comma, the learned trial court on examination of profound defendant number 2 found him to be a person who could not speak, and he was found to be physically disabled on that count. Stop. Therefore, merely because a plea is taken that the profound defendant number 2 was of unsound mind, the same is not found acceptable as the appropriate steps which are required to be taken for determination of a person to be of unsound mind was not followed and not pressed by the appellant. Full stop. As the PW2 had admitted that the sale deed was signed by him as well as the respondent, profound respondent number 3, comma, the court is of the considered opinion that the appellant was able to discharge his burden of his burden to prove his title deed, which is exhibit 2. And therefore, there's no substantial question of law involved. On the said point raised by the learned counsel for the appellant. First off, as regards the third point raised by the learned counsel for the appellant, that it would be the boundary of the suitland which will prevail. The court has already expressed his opinion on the point, but this is discussing point number 1, and therefore the dispute with regard to the identity of the land is a pure question of fact and not a question of law, and cannot be determined without examining the facts. The court is of the considered opinion that no substantial question of law is made out for adjudication on the third point raised by the learned counsel for the appellant. First one, next para. Accordingly, court does not find this to be a fit case for admission of the appeal, as no substantial question of law arises for determination in this case, and accordingly this appeal is dismissed at the admission stage without issuance of notice on the respondent. So let a decree be drawn up and transmitted to the learned trial court for making it a part of record. Yes, the matter was adjourned, Mr. Singh.
39.
39. Yes, what is your objection? You are the petition, you are the respondent person. What is your objection? Please come here.
Which is earlier 2022. 2022. An appeal was filed under the same section by the Deputy Commissioner Nogam. This land acquisition matter, along with the delay combination petition of 7 days. On 15th of November 2022, Lordship, the delay was condoned, and appeal came before the Honorable Court. Appeal was dismissed on the ground that the Deputy Commissioner does not have a locus standi to maintain an appeal. On the same ground, it was dismissed. Lordship, under the 2013 Act, Land Acquisition Act, there is only one appeal provided. This is a repeat appeal.
No, we don't find it. You file an objection, we don't find it to be a repeat appeal. You see, what is your name?
My name is Hareshwar.
Hareshwar Bora. Mr. Bora, you see, every individual is a different individual. A deputy commissioner is a different authority. Union of India is a different authority. Union of India is railways. Huh? CRPF. So it's a different entity. So notwithstanding that the appeal of the deputy commissioner is dismissed, you don't find that the appeal of the Union of India can be dismissed on the same ground.
Besides, there are other grounds too,
We have to file an objection.
Lordship. And
Today their prayer was for adjournment.
Lordship,
You want to file an objection.
I want to file an objection.
We'll give you an opportunity, but today we are adjourning the matter, but we are granting you an opportunity to file an objection.
Today, our purpose of coming here to only to seek permission from the Lordship to allow us to appear as respondent in person.
No, you may do so. You see, we have no objection in persons appearing. You have a right to do it. But the question is, if you feel satisfied that your interest will be well taken care of by your own appearance, we don't mind it. But you will have to keep a track of the cases whenever it is listed and we hear, because you will not be given notice on each and every date. Correct? Okay.
Lordship, will you give us permission to receive the copy of the I?
No, no, we'll provide you with a copy. We'll give you a copy. She will, pardon me? Please speak loudly. I'm not hearing you. No, whatever, but give him a copy. Correct. In course of the day, make a photocopy and give it to him. For this LDB counsel for the counsel appearing on behalf of the DSGI for the applicant, Mr. J. Singh, learned counsel for the government advocate appearing for the respondent number 1, and Mr. Harishwar Bora, learned the respondent number
For 2 and 3.
number Harishwar Bora and Srimati Madhumita Bora, respondent number 2 and 3, who have appeared in person. Next para. The petitioner, the respondent number 2 and 3 in person shall file a memorandum of appearance before the registry, which will be tagged in with the record of the next para. The learned counsel for the applicants shall provide a copy of the this interlocutory application to the respondent numbers 2 and 3 in course of the day. Next para. The respondent numbers, the respondent in person number 2 and 3 are permitted to file their objection. That is 2 days prior to the next date of listing. 2 days prior to the next date of listing. List on. When do you want? How much time?
4 weeks.
Okay. 4 weeks. We take it up in the third week of November then.
Lordship.
List on 20/11/2023. 20. November 20. Next para. Matter since adjourned on the prayer made by the counsel for the applicant. List on so and so. I just want to add one more line. The registry shall reflect the name of the respondent numbers 2 and 3 as respondent in person in the cause list by listing the matter next. Okay.
Item 17, daily list.
Yes.
My lord finds the proposed questions at page 7, madam. Before that, I think just quickly take the facts in a nutshell.
Just a moment. Unless I refresh myself, nothing will. I'll not remember anything. Just give me 2 minutes. You are the plaintiff for the you are the plaintiff. Your suit was dismissed. Appeal was also dismissed. There was a mistake in your prayer.
There was a mistake in my prayer. Otherwise, the findings were in my favor.
But would that be a substantial question of law?
But under such circumstances, could the court have not molded the relief? That is because when I will find the issue of title and the validity of my sale deed were both held in my favor. But eventually the court held that I could not have prayed for partition. But there were other reliefs in the prayer clause which were tenable.
Where is your prayer in the
Page
plaint?
12.
Page
12.
12. Okay, this question is new to me, admit it. It may not be a good point for it's an interesting question. I've not found a direct case law on the point.
When we try, in fact, substantial question of number 4 also, we are yet to find an authority. Because the courts have held that partition can be granted only if it is in respect of joint property, ancestral.
No, because otherwise it will be a perfect partition within the meaning of the land and revenue regulation.
So there again, my lord, if there are disputed questions of title, eventually it will be forwarded to the civil court. And
That's why, since I didn't get a direct decision on the point. We'll admit it. But Mr. B.D. Cullen, counsel for the appellant. Next paragraph. The suit of the appellant was dismissed on the ground that the suit for partition would not be maintainable. Although it is projected by the learned counsel for the appellant that he could otherwise prove whether the appellant could otherwise prove his right title interest. So the dismissal of the suit was upheld by the learned first appellate court. And thus this appeal. Next, this appeal is appeal under section 100. CPC is directed against the first appellate judgment and decree dated page 2. So the appeal is admitted for hearing on the following substantial questions of law. Whether the learned courts below had committed error of law in dismissing the suit of the appellant on the ground of untenability of the prayer for partition, whereas the claim of right title interest and possession was substantially found in favor of the appellants. Next, number 2, whether it was permissible for the learned courts below to mold relief within the meaning of Order 7 Rule 7 CVC rather than dismissing the suit of the appellant on the ground of defect in the prayer for partition. Next paragraph. The applicant is permitted to raise any other substantial question of law which may arise in course of hearing. Next para. That the records be called for expiration notice return available on return in 4 weeks. Sorry, make it 5 weeks. The applicant shall take steps in course of the day for service of notice on the respondents. How many respondents?
Just second.
7. So within 2 days. For service of notice on respondents, registered post with the AD as well as by usual process. Next, the counsel for the applicant is permitted to collect the postal track, postal receipt number and submit postal track report prior to the next date of listing.
Can be taken up on beginning one. Item number 49. No, my lord, can it be taken after petition?
After the
Or the interim order shall continue. My other side is there, but they have taken, they have said their senior has also not come today. My lord, consent. Senior is not coming, no? Oh, my lord. The application, my lord, there was a police report has come in our favor, so it has continued. Can it go on the opening day, my lord?
Item 26. Printed item 26.
For some accommodation for today. I'm led by Mr. Senior Counsel, Mr. Goswami, sir. Can it be after the petitions?
well, both sides are represented on the pair made by Mr. A.K. Barwa, counsel for the petitioner, list after ensuing vacation.
Alright.
You have the case diary with you?
Lordship, I have not received the case diary, Lordship. In the order.
No, wherever it comes, I think,
It has come for order.
Order.
no notice has been issued. This is I in, what do you call to? Oh, actually, this is for expunging the remarks. Okay, here is not required. Okay, after vacation. Okay,
Alright, you go.
27.
27 will be.
No,
That's a date people will be.
okay.
After 2000.
27 item.
Item 27.
Yes.
In I for cancellation of bail.
Okay, sir.
Oh, cancellation of bail. What is the ground?
After getting bail, they are scheduling us to file stated ground page number 6 lot the para student. 6 and 7 lot. They're scheduling the witnesses of not to give any statement against the law.
You are basing your application on annexure 5. And you want us to believe that he has been threatening you.
Yes, lordship, prior to logging it of this after lordship.
This application was filed in 26/5/2023. What has happened thereafter? In annexure 5 proceedings, what has happened?
Lordship, your lordship was granted bail to the
My question is referring to annexure 5. What has happened to that proceeding? Today we are in October, 5 months has gone by. What has happened in this?
Nothing has happened. Nothing has happened.
Nothing has happened. So that is understood. Somebody is threatening you with dire consequences of killing you after granting of bail. And very conveniently, you go to the district magistrate, file an application under 107/145. And then you want us to believe that you have been threatened.
Yes, Lordship. This application was filed on.
This is not a normal conduct. If you are threatened, you will go to the police first. You don't file an application before the district magistrate for drawing a proceeding under 107. If that is the ground, we are dismissing it. There is no point in issuing a notice on this. It's unsubstantiated. And there's 107 proceedings pending for last 5 months and you're not bothered.
Lordship, after this proceeding started after allowing this FIR loss.
I understand.
After that, they have,
I understand. Please also understand that for about 30 years, I was there. The place where you are standing, I was there for 25, 26 years. I was there. So I have some experience in conducting cases of 105.
then may I
For
get-
5 months, I don't find that if I go back, I don't find any of the proceedings drawn up in my conscious memory to be kept pending for 5 months, 107 proceeding.
Lordship, then may I get instruction from my client what happened with this proceeding last?
No, we'll dismiss it. You take instructions, but this is something which is not convincing.
Lordship, then-
Merely on 107 proceeding, you want us to cancel the bail. That is not going to happen.
Lordship, let's wait for date, Lordship. My senior will tell us, right?
Mr.
R. Islam.
R. Islam, counsel for the applicant, has prayed for notice in this application under section 439 within bracket 2 CRPC for cancellation of bail. A. Begum Lund APP is present. Next para. The petitioner, for the applicant, wants the court to believe from an application filed before the district magistrate under section 107/145 CRPC that his life has been threatened. Full stop. The said application appears to have been filed on 26/5/2023 within bracket annexure 5. And it does not appear that any orders have been passed in the said application. So, this said application, instead of approaching the police, is not found to be a convincing proof of a threat to the applicants. Full stop. Nonetheless, on the prayer for adjournment made by the Lund counsel of the petitioner, the matter stands adjourned today. List after ensuing vacation. 56. Yes.
I was supposed to take instruction in regards to the name of the father of the accused person.
Yes,
Sitaram Sen and Sitaram Nair both same person.
but it's very hard to believe here. And this application of sale that remains uncontroverted.
That the application was made, Lordship, but now the plan has been changed. Now plan has been changed. As per the application.
But that would not be a convincing ground to grant bail.
Lordship, I have any other relative who is to pay suit from.
It's your choice. We permit that. If you can show us the solvent security, we are not averse to it. since it's quite a long delay, you file an affidavit and give it to the other side a copy.
For surety.
For surety, yes.
I can find an affidavit stating that the both are the same person, Nai and Sen, Sitaram Sen and Sitaram Nai.
No, that's okay. But you see, this document we will not accept because the land documents on which you see, the land documents on which you are referring to. In this regard, Mr. Akhtar Ahmed has demonstrated from the Seva Setu that you had applied for sale for that land. So therefore, that acceptance of that land is out of question. Once you have expressed your idea of disposing of the land, we don't trust the mother of the applicant who has made this affidavit. So therefore, it's only because of delay that we are granting an opportunity of showing us. But you give an advance copy so that Mr. Ahmed can make inquiry. Huh? Suggest a date when you can file it so that we give 10 days time to Mr. Ahmed to respond, and then we take it on board. No, please suggest a date by which you can file so that Mr. Ahmed can seek instructions and we list the matter in the court on some other day. By 10th you will file. Okay. Mr. A.K. Sharma, counsel for the on the last occasion when the matter was listed on 13/10/2023, Mr. F.K.R. Ahmed, counsel for the informant, had produced a document downloaded from information downloaded from Seva Setu, SEWA, SETU, citizen-centric service of the government of Assam, showing that the mother of the applicant had applied for sale permission in respect of the land which was offered as surety for bail. Therefore, so moreover, there was a difference in the name of the husband of the and the name of the father of the applicant. The learned counsel for the applicant has submitted that the father of the applicant had used two surnames and that both are the same person. Nonetheless, as the mother of the applicant has applied for sale permission in respect of the said land, the court is disinclined to accept the same as an acceptable security for grant of bail. It may be added herein that the application for bail has not yet been accepted by the court. Next para. Accordingly, on the prayer made by the learned counsel for the Mr. A.K. Sharma, learned counsel for the applicant, is permitted to file an affidavit to bring on record any other acceptable security for grant of bail. Stop. As prayed for, time is granted till to the applicant till 10/11/2023 to file an additional affidavit with service copy to Mr. F.K.R. Ahmed, counsel for the informant. Stop. The learned counsel for the informant is granted a week's time to obtain instructions. List on 20/11/2023. Please give him an advance copy so that you can get it faster.
Item 54.
Where is the impugned order of the trial court? Order of the trial court, where is that?
Page 138.
Page
138.
1. Oh, heard. Mr. Anand Jal and counsel for the for the petitioner. This application under Article 227 of the Constitution of India, the petitioner has assailed the order dated 29/9/2023 passed by the Learned Additional District Judge number 1, Kamrup Metro Guwahati, in Misji case number 120 of 2023, in Miss Appeal number 25 of 2023, as well as order dated 29/9/2023 passed by the Learned Additional. No. Okay. No, only one. Oh, so this is the matter which we adjourned in the morning. The issue of 227 and 115.
The eviction can be passed.
I just remember now. You see, I've forgotten the context. In this 227, I don't find that the what you call the power under order 39 rule 1 and 2 can be invoked.
Regarding 227, your lordship, the lemma judgment is Surya Devi Rai.
Pass it on.
In that case, your lordship, the same thing here also, your lordship. The injunction application filed before the trial court, it was not granted, it is after appeal not granted, then
before the High Court, Your Lordship. Wherein, Your Lordship, it was rejected because 105 is not mentioned in view of the Your Lordship amendment. Then here it is, it can be assessed under 227. Only one paragraph I want to refer Your Lordship, paragraph number 25. Power of Your Lordship under 227, and it compared with the power under 226. Your Lordship.
Para 24,
25.
25, huh?
Upon review of deciding the case and survey of the opposants, while the High Court practice probably this is the reason why it has become customary with the lawyer leveling their petition on of the common under Article 226, 227 of the Constitutions, though the practice has been depreciated in some judicial pronouncement. Without entering into the necessity and technicality of subject, we venture to state the broad general differences between the two jurisdictions. First, the writ of certiorari is an exercise of its original jurisdiction by the High Court. Exercising of the supervisory jurisdiction is not an original jurisdiction. In this sense, it is akin to the appellate jurisdiction and the corrective jurisdiction. Secondly, in the writ of certiorari, the records of proceeding have been certified and sent up by the inferior court of the tribunal to the High Court. The High Court, if inclined to exercise its power, may simply annul and pass a proceeding and then to do no more. In exercise of the supervisory jurisdiction, the High Court may not only pass and set aside the impugned proceedings, judgment, order, but it may also make such direction as the fact and the circumstances of the case may warrant, and may by way of guiding the inferior court or tribunal as to the manner in which it would now proceed further or phrase as commencement to or guide by the High Court. In an appropriate case, the High Court, while exercising supervised jurisdiction, may substitute such a decision of its own in place of impugned decision as the inferior court or tribunal should have made. Lastly, the jurisdiction under Article 226 of the Constitution is capable of being exercised on a prayer made by on behalf of the party aggrieved. Supervised jurisdiction is incapable of being exercised as well. So here in Your Lordship, 227, the jurisdiction under 227 is a wide. Your Lordship can substitute your order, Your Lordship, by setting aside, by giving direction or Your Lordship. The power is there, Your Lordship, under 227.
No, that can't be accepted for a simple reason that the trial court in an injunction application has merely issued a notice.
Your Lordship.
So it's not a decision.
Your Lordship, it may not be received by Your Lordship. One thing, while issuing the notice in my appeal, Your Lordship, the court has admitted my appeal for hearing, Your Lordship.
Correct.
And if he admitted.
You see, if it is not admitted, you don't even have a prima facie case for issuance of notice in an injunction application.
Admitted for hearing, Your Lordship, then while the if it is admitted, Your Lordship, there is a material in my appeal. So if admitted for hearing, Your Lordship, in the trial, in the injunction application, only notices simply Your Lordship not saying anything about the facts why I am not entitled for the.
No, Mr. Jha, that's not acceptable. For the reason that, you see, it's a prima facie case for admission of the appeal, and therefore appeal is admitted. But the other two factors are not decided in issuance of notice. It's not a necessity of the trial court or appellate court to also give a finding on the other two factors of injunction, that is balance of convenience and injury also. That's not required. But if it is a prima facie case, it is admitted, appeal is admitted, and notice is issued.
The case is there, Your Lordship. Apart from this, Your Lordship has a power under one type one. The judgment is there.
You see, listen, Mr. Jha, you see, what we do is at times, it is a manifestation of a mechanical manner in which we are passing orders. Correct. You see, an order under order for an appeal under order 43 rule 5, rule 1R is a statutory appeal. Correct. So in a statutory appeal, except for section 100 where there is a prescription of formulating a substantive question of law, am I required to record my satisfaction for admitting the appeal? Say 96, appeal under 96. Does the court have to record satisfaction that yes, it is worth admitting?
That may not be recorded in admitting the appeal.
So therefore, you see, when in order 43 rule 1R appeal, when we say that prima facie case is there to admit and then send, that prima facie recording of prima facie satisfaction is a mechanical exercise. It is not statutorily required. Nowhere you will find an authoritative judgment which says that unless satisfaction is recorded, an appeal should not be admitted for hearing.
First recently, emergency situations, where having this project and they are raising the construction.
No, that is okay, but what I'm asking you is,
Some form of protection.
no, no.
That has not been done in this case.
Mr. Jha, you see, I'm trying to understand the proposition because what I'm trying to, what I will be doing will become a law.
Yes.
Correct. Now the question is that the trial court as well as the first appellate court issued notice in your injunction application.
Yes.
Number one, is that a decision on merit which can in which 227 can be exercised? That is number one. Because I can substitute the decision of the trial court with my own satisfaction. But you see, for the purpose of injunction, it's the satisfaction of the court which is to be incorporated. The trial court did not have that record that finding in your favor. So therefore, High Court in 227, when it is granting an injunction, is recording a satisfaction which the trial court had not.
Power is vested to this.
No power. We are not saying that we don't have the power, but the issuance of notice is not even.
Power is there. However, you not notice maybe I'll set it down the next.
Because tomorrow we are not. Tomorrow is the last day of.
After vacation, you must.
Then it will become infructuous by then. Your next date is on 30. 30 is the date after which your application becomes infructuous.
And you must maybe tomorrow. I'll try my limit.
Okay, try to get something because it's a decision which can be reversed under 227. That we have no difficulty in understanding that. But the riders in 227, although in Suryadevi right is not there, but subsequently there are several judgments, including judgment of 1966 by a constitution bench of the Supreme Court, where it says that power of revision can only be exercised in case of perversity. So, because unless you see issuance of notice, I will find it to be perverse. Till then, I don't have the jurisdiction under Article 227 to pass an order.
There.
There's also a, what do you call, I forgot the strength of the bench. 66 and 67, you will find two judgments. One out of these two is a constitution bench judgment on the power of High Court in exercise of revisional jurisdiction. So therefore, when you are using 227, I must also be satisfied that the non-issuance of injunction would amount to perversity. Otherwise, we don't derive that power. Please do that when you are doing the research. Please do the research on that line also. Okay, this is matter on tomorrow. I'm giving you back this Suryadevi Rai. Tomorrow you may address me again. You have raised a good point, but question of jurisdiction comes in again. $55. Heard Mr. Studi, counsel for the appellant. By this appeal under section 28 of the Hindu Marriage Act, the appellant, who is the estranged wife of the respondent, has assailed the judgment and decree, page 1 flag. Please admitted for hearing, call for the records. Issue usual notice to the respondent, returnable on in 4 weeks. The appellant shall take steps within 2 days for service of notice on the respondent by registered post PDB as well as by usual process. The learned counsel for the appellant is permitted to collect the postal receipt number and submit postal track report prior to the next date of listing. In the right, if the connected appeal has been admitted for hearing, heard Swenson, admitted for hearing, comma, the court is inclined to stay the operation of the judgment and order dated 10/8/2023, same order, so and so. Next. Here also take steps. Returnable in 4 weeks. Still the registered post on the registered post. Okay.
Item 18. Item 18.
It's a division bench matter. Yeah, please, yeah. Division bench matter. None appears on call for the parties. It appears from the previous orders that this matter was previously heard by the full bench as well as the division bench of this court. So therefore, the registry shall examine and list the matter before appropriate bench. So it may be noted that in the order dated 26/2023, it has been reflected that this bunch of petitions were tagged together and posted before the specially constituted infrastructure bench. So let this order be brought to the notice of the registrar in bracket judicial. Item 20.
Inadvertently, I don't find the proper application for correction of the post rate of the IA. Sometime maybe.
Okay. On the prayer made by Mr. D. Mandal, counsel for the applicant, the matter stands adjourned today. They start application.
Hello.
Mr. Miss A. Hussain, counsel for respondent 3 is present.
Oblige.
21.
Yes. Yes, I am in the appeal. We are not in this case, is your
Just a moment.
already is hearing. To be discussed with the hearing list, my lord. In your court, but my prayer is, my lord, regarding that my daughter is going, marriage ceremony, my daughter's marriage ceremony will be held on in the month of my lord, December. So, my lord, this, petition our, my lord, pray before this, our good to hear the matter, my lord, opinion, in the month of November.
No, I think you'll have to file an application. Because there is a judicial order to list it in due course.
I'll find one.
You file an application because we can't, don't want to override the judicial order of the court. 10/3/23 is the judicial order to list it in due course. On the learned counsel for the appellant and the respondent one are present. On the prayer made by learned counsel for the appellant, list after ensuing vacation.
Item 22.
I, for disbursement of the amount modified by the insurance. Same amount. Pursuant to order dated 23/1.
Okay. No objection.
Lordship, subject to punishing of indemnity bond, Lordship.
Why?
Lordship, because when the bail was not valid, Lordship, at the time of accident, the bail was not valid. And the indemnity bond may be punished by the owner of the vehicle.
No, what has happened? Please repeat again.
The driving license was not valid, Lordship. It was, the.
Acha, driving license is not very, okay.
By the
Okay.
order.
Yes, indemnity bond has to be punished.
By the.
Okay. But he's not the owner.
Yes.
The applicant is the owner.
No, I'm the.
Owner is liable, Lordship, in this case,
No, I understand, but why would he give a bond?
by the owner, Lordship.
He's not the owner.
Yes, yes. Then Lordship, let them, they have already appeared, Lordship, for this 2 and 3 service is complete, Lordship. Service is complete and matter is, lawful record was followed.
No, that is different. What about this prayer? Because we can't direct them to the applicants, we can't direct to give a bond. The driver and the owner, they may appear, they may not appear, we don't know. But he's, Bora is not required to give us a bond.
There the another matter, lawful record will be-
No, but if the deposit money is lying here, why should we not release it? He has died. His
They
who
have
has
already
died?
deposited.
Husband,
Mother.
mother of the deceased.
The mother.
Lordship, wife.
Wife.
Wife, okay.
Yes.
Women are, sons are also there.
There major son, they are the performance. Performance based.
Heard. Mr. B.P. Bora and counsel for the applicant and Ms. M. Chaudhary, learned counsel for the opposite party number 1. Next, this interrogatory application has been filed by the respondent, claimant. Respondent numbers 1 to 4 of the claimant for release of sum of rupees 4 lakh. 4 lakh.
Not 1 to 4, okay, 1, 4, 5, 6. 2 and 3 are different. 1, 4, 5, 6 are the claims.
1, 4, 5, 6. Okay, 1, 4, 5, 6 claimants. Allowing them to withdraw for sum of rupees 4 lakh, which is lying with the registry of the court. Pursuant to
Dated 23/1/2020.
order dated
23/1/2020 in IA 3844/2019.
23/1/2020 passed by this court in IA Civil
3844/19.
3844 of 19.
Right.
Full stop. Next paragraph. The no, not continue. It is submitted that there was an award for a sum of rupees 7,41,000 with interest at the rate of 6% from the date of filing of the claim petition. Next paragraph. The learned counsel for the opposite party number 1 has objection to the prayer made in this application on the ground that on the date of the accident, the driving license of the opposite party number 3, who was the driver of vehicle number 3, namely Prashanta Barua, Prasant Barua, Bruh, driver of vehicle number AS 19B 1818 was not valid. And accordingly, she has submitted that the withdrawal may be made subject to submission of a bond. Next paragraph. The court is of the considered opinion that as the husband of the applicant number 1 and the father of the applicant number 2, 3, and 4 has expired, who was the victim of a motor accident. There is there would be no requirement for the applicants of the claimants to file an indemnity bond. Full stop. At best, such a bond may be required from the owner or driver of the vehicle. Full stop. Therefore, the court is inclined to allow this application by directing the registry to release the sum of rupees 4 lakh to the applicants who are respondent numbers 1, 4, 5, and 6 in the connected appeal. So withdraw the sum of rupees 4 lakh, which is lying deposited before the registry of this court on being satisfied as to the identity of the applicants. Next paragraph. This interlocutory application stands is kept pending so as to enable the learned counsel for the opposite party number 1 to renew her prayer for having a bond to be provided by the owner of the driver, as the case may be. Full stop. This liberty to mention is allowed. This application is adjourned sine die. IA civil. Then appeal records have come.
Lordship, Lord was no lordship. That was-
Service is complete in the appeal.
Yes, lordship. Service is complete as per order dated 23/25.
Okay.
Reminded
In the connected appeal, right? The counsel for the appellant and respondent numbers 1, 4, 5, and 6 are present. None appears on call for respondent numbers 2 and 3. So the registry shall take first steps for requisitioning the LCR Next, list after 4 weeks awaiting receipt of LCR.
Notwithstanding the tendency of this IA, also the claimants can collect them.
I've allowed it.
Item 23.
And what if here we, again, we have to take Rescission, my lord, on this corner number 3, my lord. By collecting correct and proper address.
No, I think the name is also incorrect. This order of the last order of the court is that the applicant is given 2 weeks time to ascertain the correct name of the respondent.
Same address.
No, something has to be wrong. This court has rightly observed. Something must be wrong.
My lord, he was driver, my lord.
No, but you see, that's why the court passed this order perhaps. The name of the driver is Rakhal Das
Rakhal Das.
and his name of his father is Nimar Ali Laskar.
No, my lord, date Ramu Das, my lord. Now
That's
we have
why-
corrected, we have corrected.
No, you have corrected with you. Unless you correct our copy, nothing is going to happen. Correct. Name of the father is late Nimar Ali Laskar. So if father of Das is Laskar, definitely court put that question. Okay. Counsel for the appellant and respondent number 1 are present. In terms of the order dated 21/4/2023 passed in this interlocutory application, we learned counsel for the applicant. Please for some more time to take appropriate steps. List after vacation.
24.
There are no 6 respondents. In fact, permission respondent 1, 2, 3 is complete. 5 and 6 is also complete. Respondent 4, who happens to be
Just a moment. Only 4 you have to take first steps.
I should put up 4, 1, 2, 3, 4, they say the same addresses. 1, 2, 3 are repeated. Maybe there is no service.
Okay, we can take okay. Heard. Mr. R. Goswami, counsel for the applicant. No, I please don't call for the opposite parties. First off, from the next paragraph from the office note dated 25/8/2023. Comment appears that AD card in respect of respondent numbers 1, 2, and 7 has been returned. Full stop. The AD card of respondent number 3 has been signed by respondent number 1. Full stop. It appears that the respondent number 1 is the son of the deceased. He is the deceased victim.
Son of the within the son of the respondent.
Deceased is the son of
Son of the claimant.
the son of the claimant. Okay. Is the respondent one is the son of the claimant. No, son of the deceased. A father of the deceased. Number one, who is he?
Respondent number is the father of the deceased.
Father of the deceased, okay. Number one is the father of the deceased. And respondent numbers 2, 3, and 4 are
Wife and his sons.
as a wife and wife, daughter, and son respectively of the deceased.
Of respondent number one.
Of respondent number one. Okay, of respondent number one. Something is wrong.
What is when he was a married man? The respondent 7 and 8. His wife and minors.
No, he's the number two is the just right. Number one is the father of the deceased. Number two is the mother of the deceased. 3 and 4 are sister and brother of the deceased. Therefore, acceptance of notice on behalf of respondent number 3 by respondent number 1 is accepted to be a valid service. Although AD card in respect of respondent number 4 has not returned back. AD card or unserved notice is not returned back, but as respondent number 4 is the member of the family of respondent numbers 1, 2, and 3, the notice on respondent number 4 is accepted to be duly served. It also appears that respondent number 5 and 6 have appeared by filing wakalatnama. None of the respondents are represented today when the matter is called. Now to number 8, no notice has been issued.
The minor record of 7.
No, but notice has to be issued. Notice has to be issued. She may be represented by major, but notice to a minor has to be issued. Huh?
Mother has received them. Mother, the minor has received them.
No, it doesn't appear from this. Here it says notice to respondent 1, 2, 3, 4, 7 is issued. Only 7 is issued by registered post. 4/1/2023. Next para. It appears from the office note dated 4/1/2023 that notice were issued only on respondent number 1 to 8. So it is seen from the cost title that respondent number 8 is a minor. Therefore, the applicant is directed to take steps for service of notice on respondent number 8 through her mother, within bracket respondent number 7. Notice is made returnable on steps within 2 days, returnable on give a fixed date after 6 weeks. Returnable on so and so. The counsel for the petitioner is permitted to collect the postal receipt number and submit postal track report prior to the next date of listing. List on so and so, awaiting service report on respondent number 8.
6th of December, 6/12/2022. Item 25.
I for restoration.
I'm sorry, Lordship, we inadvertently missed the Lordship item, Lordship, point letter was spot on.
Okay, what is the What is the matter? CRPIO.
Yes, Lordship. Yes, sir. Order 41 rule is 27. Order for the additional.
Okay. Any objection? We allow this application? Okay. Heard Mr.
Yes, sir.
S. Ali, counsel for the applicant. And Mr.
J.A. Sikdar.
J.
A. Sikdar.
A. Sikdar, counsel for the opposite party. You are appealing for all?
One and 3A.
1 and 3A2?
3A, B and C.
3A, B and C.
I'm sorry, on.
No, we can't do anything. This can't be restored. In the CRP, there is an office note that respondent 2 has died.
Lordship,
No, you don't understand. My statement has some relevance because when I am restoring a application which was dismissed for default, notice on the other side is necessary.
I need to find the Lordship, representative of the Lordship, the legal heir Lordship.
No, that I don't know, but you see, today I can't restore it. That is the only point, please try to understand. Application which is dismissed for default can't be restored in the absence of the party, and now this party has expired.
See, after filing Lordship, CRP Lordship, we come to know that Lordship there.
No, that I don't know. I am not applying my mind right now. I'm just indicating. I'm just indicating. Students who are present. It appears from the office note dated 10/11/2022 that respondent that as per process service report, respondent number 2 has died. First off, in view of this said office note, the matter stands adjourned today. List after ensuing vacation, so as to enable the counsel of the applicant to do the needful. I'll take a few prayer made for upgradation.
65.
Some urgency was expressed.
Item 65 upgraded.
Here my simple prayer is.
We can pass till the next date of listing. Interim order can be passed till the next date of listing. You filed an application.
The property was directed to register this case CRP, and there's an interim prayer in the civil division petition. As per the indication, your lordship was supposed to consider my interim prayer in the.
No. You see, we adjourned on the last occasion. This matter was adjourned earlier, right?
Actually, yesterday.
Yesterday.
I filed a petition under order 14/5. Petition, however, it's not applicable. What the different,
No, where is Dasi? Yeah, order to आना है थे. No, I don't remember the context. In fact, yesterday what had happened, I had forgotten.
So yesterday I filed the petition under order 41 rule 5.
Yes.
For stay of the execution.
So this is a CRP.
CRP, it is not
In
applicable.
CRP, it is not applicable.
So your lordship closes that petition filed under order 41 rule 5. The indication that my CRP will be listed today because there was a delay petition and your lordship was pleased to condone the delay in filing the civil review petition.
Is there an interim player here?
Here, yes.
It is available.
in the
Where is
civil-
that?
in the civil revision page.
It was closed.
দুইটা ক্লোজ ছিল ফাইল নাম্বার সব কথাই ছিল আমি একটু আমি রেজিস্টার করিয়ে নিছিল
না ঠিক আছে কিন্তু কোনটি ক্লোজ হয়েছে?
এই এই দুটা এই আছে ইয়াতে দুইটা এই ক্লোজ
হ্যাঁ, সেটা আছে ওকে এই অর্ডার বানাই দিব লাগাই দিব
At page 13, there is an interim prayer.
জাস্ট আ মিনিট So now my quota has explained because yesterday the signed order could not be typed here. In the meantime, we got it done because of your prayer, but that order is not there, so I forgot the context. Okay, heard. Mr. S. Biswas, learned counsel for the petitioner. Also heard Mr. Z. Mukit, learned counsel, appearing for the respondent caveat. You're appearing for all?
Yes, but for the plaintiff.
All the respondents. Next para. This is landlord tenant dispute.
Yes.
Oh, okay. The petitioner is the defendant in TS 16 of 2015 has preferred this revision under section 115 CPC, challenging the first appellate judgment and decree dated 18/8/2022, passed by the learned civil judge Bongaigaon in TA number 13 of 2018. They were dismissing the appeal of the petitioner and affirming the decree of eviction passed by the learned Munsif Bongaigaon in TS number 16 of 2015. Next, but I should notice on this revision without requiring the petitioner to take steps as the respondents have appeared by filing caveat. You've got copies? You have received copies?
No, but revision copy we don't.
Oh, okay. Good stuff. The copy of the revision application along with all inclusions be furnished to the London Council for the respondent in the course of the day. Next para. The London Council for the petitioner has prayed for a stay of the execution of the decree during the pendency of this revision. Full stop. The said period has been opposed by the London Council for the respondents. So it is also submitted that the realization of rent which was decreed from April 2014 to December 2014 has not been paid. Full stop. In connection with this said submissions, the London Council for the applicant has submitted that petitioner has submitted that as per his instructions, as according to the petitioner, the tenancy was a yearly tenancy, annual rent has been deposited for the subsequent years till date. Next paragraph, considering the fact that if stay is not granted, decree may be executed. The court is inclined to stay the execution of the decree referred above till the next date of listing. Next paragraph. However, prior to the next date of listing, the petitioner shall hand over a check for the area rent of rupees 9,800. Right,
10,000. 10,000.
From
For
April,
9 months at the rate of 1,200.
April
It'll be-
2014 to December.
how much?
10,800.
No, yesterday he made 9,800. Just do the calculation.
10,000.
10,800. 10,800, okay, 10,800. Drawn in the name of respondent number 1,
Right.
wife, or respondent number wife, Srimati Shamali, SHYAMALI, DE. This shall be handed over to the learned counsel for the it will give you directly there or here?
As your lordship promised, because they can deposit it in the trial court also. In the trial court also,
It can be deposited there also.
there also, or before this registry also.
No, once it goes in, again, you'll have to file an application, withdraw it. So therefore, I'm trying to ease out the procedure.
As your lordship directs.
To you also, it will be done or there, handed over to the personally. Or to the learned counsel for the respondents at Guwahati for onward transmission to the respondent number 1. First, it is provided that if check is received by the respondent number 1 directly, acknowledgement shall be issued as a proof of receipt. Full stop. List the matter after 4 weeks. Make a mention if it is not listed.
Right.
69.
The trial court has not passed an interim order. Again, regarding appeal and this court passed an interim order. Our contract was up to 2025 February. We also done in the past. Now, if the matter is heard by the charge malord in the trial court, the matter can be remanded back. Till then, malord is between order passed by this court.
Where is the order of 2/6?
Sixth order is my lord annexed to IA number 2540. Filed by the respondent.
In the IA 1520, it was passed.
It was passed in IA 1520, but my lord, it's annexed with IA 2540, page number 29. Operative part, my lord, page number 30.
Okay, how you, this I is by whom?
IAS by the respondent on the.
You have filed this. What is your ground for this application?
Why not, according to us, my lord, they have said that behind their back, the fresh tender process was taken to let out the buses. My lord. But my lord, in the fresh tender process, they have taken part. My lord. That part they have twisted. My lord. That's why under order 39 rule 4 I have come. And in the fresh tender process, they are L2.
On this, my lord, then it will be accepted.
Just a moment.
At one party, I filed an application for any.
Just a moment. Since you're down below, I could not can't get time yesterday to read this. So therefore, I'm
So many matters are.
so therefore just give me 2 minutes. Yes. Okay, I now get it. Is the copy of plaint available?
$99 in the IA. Page 99 in the IA. 1.5.
No, 99 here in my copy is one
And it's a nine.
BPS price bidding,
IA, 1.5.
1520.
39 rule 1.
Your case is that the
My contract is valid up to
agreement, the valid up to 2025.
for 8 number of 7 as well as plus 1.
But Mr. Savala, if once you have participated, it amounts to waiver.
No, well, that is not a valid care. Because my, I don't know whether that those then services will be replaced by me.
Pardon me?
My buses will be replaced. My contract was very up to 25. We may have invited tender for 10. We can do.
No, but if you have participated in the tender process,
Tender would have different. Allow new additional buses, my lord. That is another aspect of the matter. That is to be done in the. Just and then there's another. We don't agree, my lord, that if the matter is to be hard because trial court has not heard the matter. Let the trial court hear the matter. Trial court issued only notice. Normally, my lord, the trial court, my lord, the letter is coming back to say.
Where is the NIT?
NIT is my lord. In I number 2540. I'm giving the page number now. We have annexed the bid of the petitioner here, my lord. In I number 2540, which starts from page number 78. It is the bid he-
2540.
yes, sir.
Page?
Page number, my lord. 78. This is the bid submitted by the petitioner, in the fresh tender process. $78.
Tender is at 81.
Tender is at page number
Page number?
81. And 80 also, my lord, the note, NIT is at 80.
EP?
80, my, 80. NIT. What you wanted to see the NIT is at page. Tender number so and so dated 10/3/2023, service requirements, hiring of transport service of 10 numbers of brand new fully built diesel non-AC school buses.
I think we can.
Now, the petitioner had an aging fleet of buses, my lord. He had an aging fleet of buses. It was in service with the school, my lord. But on and from, my lord, 2/3/2022. After it was extended, my lord, in the year 2020, from 2022, the problems have started because the buses were aging, my lord. So ultimately, my lord, at page number 75 was the last incident, which forced us to take the decision for the fresh tender, my lord. And his consent was also sought, my lord. His consent was sought, and then he came forward, the petitioner came forward and asked for this experience certificate. My lord, that experience certificate we had issued annexure N, page number 76. my lord. That's the type, my lord, type of the. Originally, it was page 77, my lord. This is the type copy. Subject your lordship will find issue of experience certificate for bidding purpose, which was written by the petitioner to the principal, APS school, Julia Janga.
You see, tentative view is that this civil court is opening up on 30.
My lord.
Uh, this the order in FAO, which has been appealed,
Right.
is only for issuance of a notice.
Only a issuance of notice, correct, my lord.
Now, this what is the next date before the trial court, or it has been stayed?
After this, my lord, this order, my lord, this 2/6 order. Interim order is given, my lord, of page number 29 of this IA.
No, just tell me, you are the counsel there. What is happening in the trial court?
I'm not the counsel there.
You're not the counsel
I'm
there.
not the counsel. Objection, we have filed.
No, no, that is separate. But what has happened to this Injunction application, what is, it is at what stage?
We have filed a,
This has been served to the, this has been served. The case is appearing there.
we have filed a response.
You file your response.
Problem is that my lord, the contract has now been granted.
Now, both of you, what do you really want? You want this court to take up the matter, adjudicate this issue regarding the interim injunction? Or you want, both of you want that this matter be relegated for a, before the trial court for a decision?
But because the trial court
The
has
trial
not,
court to the decision, because the trial court has not heard the things on merits till now. It was just notice was issued against that. They,
No, I understand, that's why I'm asking, because otherwise, whatever order I pass, then you know where the forum is, next forum.
yes. That is
So
why.
but this, if this order remains, this interim order remains, then also, my lord, it will be some sort of an influence to the trial court now.
Hmm?
This interim order, my lord. If that
We
also-
won't say anything, because then we won't modify the order. We say that on your, fix a date, 30 October it is opening.
My lord.
We fix the date on 1st or 2nd of November, on that day you appear and the court will, what you call, this, will take a call on this in the injunction application. And this order which is being passed by this court, that will come to an end on that day.
My lord, that may be indicated. If that is indicated, I have no problem.
This order of this court in this IA would lapse on the date of appearance, 31st or 1st of November. When do you want?
That's my learned senior.
31st October or 1st of November?
My lord, both of us, we are not fearing the trial.
No, it's okay.
Second of
No, no, you can always phone and tell,
Yes,
Second of November. one. Second of November.
2nd of November. Okay. You have the mode of communication, so no issue with that. And
Petition 3118.
3,
118.
118. We are closing this application.
Yeah.
We are applying there.
You can press the application there.
Mrs. Saiwala. See, there is a reason why I did not want to pass any orders here. Can you think of a good reason why I'm not taking up this matter? I'll tell you. In a commercial suit, before it is adjudicated, it must go for a conciliation. That has not been done. So therefore, the proceeding itself ought not to have been taken up before the mandatory conciliation proceeding.
No, urgent matter, my lord, it can be done. I can place my lord. If necessary, I can.
I don't think that is that can be waived.
Today I have not got that much more. I can.
No, no, Commercial Courts Act. Commercial Courts Act. Because in a commercial suit, a third party would also not have a right to be implicated just on asking.
Well, A, Malak.
12A, one, but there's been an interpretation that it's required to be mandatorily undertaken.
So only will urgently they can.
Okay, 12A is there. Okay. This will be ordered in. I'm passing this order in FAO.
Yes.
Heard Mr. G.N. Savla, Learned Senior Counsel, assisted by Mr.
HK Sharma.
H.K. Sharma, counsel for the appellant. Also heard Mr. M. Mr. Z. Mukhi, learned counsel for the opposite party number, respondent number 1. 1 and 2. Along with Mr. K. Kalita, learned counsel. Also heard Mr. S. Nath.
This interim order is occurring me because I am the valid bidder. I purchased all 10 buses. I financed them, and from this month I have to pay 600 rupees a GM.
Okay, you be there. It's not learned counsel who has for the applicant who has filed IS Civil 3118 of 2023 for impleading him as a respondent in this application. Next paragraph. The appeal is preferred under Order 43, Rule 1 within bracket small r CBC. Against the order dated 12/5/2023, passed by the Honorable Civil Judge Dibrugarh in Misji case number 74 of 2023, in commercial suit number 2 of 2023. Full stop. By the said order, the trial court had issued notice to the respondents to notice to the respondents as defendants to show cause. As injunction under Order 39, Rule 1 and 2, CPC was not granted, the said order has been assailed in this appeal. Next paragraph. On a query of the court, comma, the learned senior counsel for the applicant as well as the learned counsel for the respondents have submitted that the proceedings of DJ case number 74 of 2023 has not yet proceeded. And the hearing in the said injunction application is not commenced. Most of the learned counsel for the respondent has submitted that they have entered appearance in the said suit and have filed their show cause reply, right? Stop. Under such circumstances, comma, when the adjudication has not been taken up, comma, the court is of the considered opinion that any observation made by this court in exercise of appellate jurisdiction may prejudice either side, as they would be deprived of a forum of appeal. Full stop. Therefore, with the consent of the learned senior counsel for the appellant as well as learned counsel for the respondents, the court is inclined to close this appeal and delegate the parties to appear before the Court of Learned Civil Judge in Dibrugarh. With that direction to the Learned Civil Judge Dibrugarh to pick up the proceedings of Nijay case number 74 of 2023 as expeditiously as possible without granting any unnecessary adjournments to either side, and make an endeavor to dispose of the said application within an auto period of 1 month. Okay. Next para. The learned counsel for the party applying for impleading has submitted that as the said applicant was the L1 bidder, anticipating the work order is
Already issued. Security has also been paid by him, everything done, LOA is also issued.
okay, as LOA, letter of intent has been issued in their favor, they have purchased the vehicle, for which they are required to pay huge installments and interest. Hence, it is submitted that the adjudicative injunction which has been passed by this court in connection with IS Civil 1520/2023 is affecting them. Next slide. Now, when we cut to the submissions made by both sides, all sides, and considering that this court is delegating the parties to appear before the learned trial court for an expeditious hearing of the proceedings of Ms. J, case number 74 of 2023. And upon considering the stand taken by the appellant as well as respondent number 1 and 2 in IA Civil 2540/2023. Specifically, the stand of the appellant that their contract with the respondent numbers 1 and 2 was subsisting till what date?
So that 10th of January 25.
10/1/2025. Comma. The court is inclined to provide that the identity injunction granted by this court by order dated 2/6/2023 in IA Civil 1520/2023 shall be enforced till 2/11/2023.
Disposal matter. Disposal.
No, that I'm not doing. Extension will be done by that court.
Well, on that same day, my lord, it may not be filed, my lord.
No, but it may extend the order. I'll provide that. Full stop. Next paragraph is provided that both all sides shall appear before the Court of Learned Civil Judge within bracket senior division bracket close Dibrugarh on 2/11/2023. Full stop. The appellant herein is granted leave to make a prayer before the said learned court for passing appropriate orders in the proceedings of Ms. J case number 74 of 2023. And the said learned court shall on consideration of the submission of the learned counsel for the parties, appearing parties, shall pass an ad interim, shall pass appropriate orders on the ad interim order on the application for injunction, fixing and fix another date for hearing the parties on the show cause. Full stop. Alternatively, it is provided that in the event the learned trial court is inclined to hear the parties on merit, it may do so, and till a decision is taken, it would have the jurisdiction to pass an identity, to pass appropriate orders in the said application till the next date of listing.
According to merits, well, let it.
No, I'm not saying anything. What to be done? It may pass appropriate orders, I am saying. Full stop. Next paragraph is also clarified that the said learned court shall not be influenced by the order of ad interim injunction granted by this court on 2/6/2023 and which is extended till appearance of the parties before the said court on 2/11/2023, and it shall decide the matter in its own merit without being influenced by the order.
My submission, my lord, one line, if your lordship, please, because your lordship has recorded that his contract is till 10th of January 2025. Per contract, I am saying that, my lord, since he took part in the fresh bidding matter, in the fresh tender, that
Okay.
line, my lord, only.
Okay, just right there. where I've said at the valid till 10/1/2025. There's a, in this connection, the learned counsel for the respondent numbers 1 and 2 have submitted that they have a valid reason for going ahead with the tendering process, as the applicants had participated in the tendering process. Just to be that as it may, this is the observations is only indicative of the submissions made by the learned counsel for both sides. And is not to be construed as a observation of the court on merit. Okay. Just a moment. Before that, you're right. The applicant in IS Civil 31118 or 2023 is also delegated to appear before the learned civil judge, senior division, Dibrugarh, and file an appropriate application, which will be considered in its own merit. Interrogatory application disposal in view of the order passed in the appeal, connected is disposed of. Closed, not disposed of, closed.
Production and also one.
Yes, Mr. Dilip Mazumdar.
Production list item 1. CRPIO 342.
Just a moment. What is the order?
Page 74.
74.
The second order. Of 21st of September.
No, but again, this is a technical question. If the injunction by way of status quo is vacated,
Not
227.
I'm aware of that. Not vacating the order as such. There is already stay passed by some report of other proceedings. Thereafter, in spite of that, somehow my friends were filing application for extension. While the court on the first date, when this order was of the honorable court was produced, court has just intimate about the development of the high court case
Where is that? Where is that order?
of the minority.
Trial court.
Trial. Page 47. Page 47. Parties are represented. Here is the content application number Spencer filed by the land council for the plaintiff and with copy of the order Spencer passed by the Honorable Guwahati High Court and CRP number Spencer. Veriture of the order shows that the Honorable High Court
Have you got that CRP IO 10, please? It is there.
Yes.
Is it on board?
Yes.
Today, item number?
Yes. But that the petition is not listed. CRP is not.
No, you see, Mr. Mazumdar, you have seen the decision of Supreme Court of India in this Asian road resurfacing. It says that the order is not extended. It stands vacated, and number one, if it is lying unattended for 6 months, then also all the interim orders are extended, are vacated. And the trial court would have the jurisdiction to proceed with the matter. You have seen that judgment.
I'm aware of that. What I'm submitting is the court below has not consciously passed the order of not extending the order. Court says that on the last occasions, when you, if you are lordship, will kindly have that order partner
47.
of, minor, that is the order of 19.6, that is available at page 4. First one. Yes, please. And that order is of 70, madam.
70.
7.
But why you did not file an IA to have that stay order extended in
File-
CRP?
We file an application, then court, we file.
No,
an
no, in
application.
CRP, that what do you call this, CRP 102 of 23.
I would be in the CRP, we didn't come here against an order of refusal or grant of injunction. We filed an application, it's a suit for extension conducted by the tenant. Tenant is there in premises. By the side, there is a vacant land. I have paid 30 lakhs to the landlord. Landlord agreed to, there is a agreement that you construct a separate structure, and for a hardware shop, I need that. He agreed to let it out to me. Now, after the construction was completed, almost completed, I had an application that he's going to give it to a third party. I filed application for, I filed a suit with an application that should not be give letter to a third party. Also for passing order of status. Thereafter, since there is a change in the thing, madam. Oh, I'm sorry, madam. So thereafter, well, what he did, instead of letting it out to third party, he himself started the business case. I never apprehended them. So there was a requirement of amending the claim. When I filed the application for amendment of the claim, the land court below says, so there is no violation of the injunction order, so amendment is not necessary. On that ground, the amendment was refused. As against that, I came before lordship and CRP is that CRP challenging the order, refusing amendment of the claim. And there further proceedings of the trial court was stayed by the court. This order I produced on 19/6/22. 19/6/23 at page 47.
Page 47.
47. The honorable court stayed the further proceedings of the court below based on the order passed by the court and says that you inform this court about the latest development of the High Court case.
Okay.
Now that order lordship will kindly find in the order of the trial court at page 69.
59.
69.
69.
This go by page 69. 69.
Yes,
Second order, 8/8/2023.
yes.
Above that, lordship kindly see the first order of 19/6. Parties are represented in view of the order passed today in the main suit, the incident mistake cases posted for necessary order on 8/8/2023. So in the main suit on orders in part, stay or further proceedings suit. Accordingly, the
No, no, in page 47,
Pilot.
this is with reference to suit number 237.
Yes,
Next date is shown as 26.
no, it's not correct. Next date is 8th of 8/8/23. Just
Okay,
above.
8/8/23.
Yes.
Okay.
Then, my lord, I'm taking a lot to page 69.
Yes, 8/8/23.
But in the
Okay.
Connected case and orders in part, and then giving to the order passed in the main suit, the instant major cases posted for necessary order on 8/8/23. We were under the impression that no further proceedings either in the suit or in the injunction matter will be.
Oh, achha. Okay. Okay. Heard. Mr. D. Mazumdar, Senior Counsel, assisted by Mr. P. Bora, Counsel for the petitioner. Next para. This revision under Article 227 of the Constitution of India. You have to strike out 151. First of all, as the impugn order and the challenge is not amenable to be assailed under section 151 CPC, comma, the learned instructing counsel for the appellant shall strike out the provision of section 151 CPC from the cost title of this application, which shall be done in the concerned section. Next paragraph. By this application under Article 227 of the Constitution of India, comma, the petitioner has assailed order dated 21/9/2023, passed by the learned civil judge within bracket senior division bracket close number 3, Guwahati, Kamrup Metro, Guwahati, in Michi case number 267 of 2020, in TS number 237 of 2020. Next paragraph. The petitioner is the plaintiff in the said suit. Full stop. It is posited that in the said TS number 237 of 2020 and connected Ms. case number 267 of 2020, comma, apprehension was expressed that in the construction done by the petitioner, comma, the landlord may induct a third party. Full stop. It is in the said context that the suit was filed. Full stop. However, the respondent landlord himself, and it is projected that the respondent landlord himself along with the respondent number 2 have entered into these suit premises to start their own business. Full stop. The same necessitated an application for amendment of the plaint. Full stop. The said prayer was refused, and accordingly, the petitioners had approached this court by filing CRP IO 102 of 2023 to assail the refusal of amendment. So this court by order dated. Yes, what is the order? 10/4/2023 had stayed the further proceedings of TS 237 of 2020. So by referring to Annexure E to this application, comment is projected that on 19/6/2023, the order of this court was produced before the learned trial court, and accordingly, the next date of the suit was fixed on 8/8/2023. On 8/8/2023, it is submitted that on 8/8/2023, as the proceedings of the suit was stayed, the petitioner was unrepresented, and the learned trial court had fixed the next date on 29/2023. Full stop. On 29/2023, the petitioner had filed a petition bearing number 4600 of 2023 to extend the order of status quo dated 2/9/2023. And the same was fixed for hearing on 21/9/2023, and on the said date, the learned trial court arrived at the conclusion that the status quo order dated 2/9/2020 had automatically vacated on 19/6/2023 due to non-filing of any prayer for extension. And accordingly, the petition number 4600 of 2023 was rejected. First of all, the said order is assailed in the present application filed under Article 226 of 227 of the Constitution of India. Issue notice return over on so and so. The petitioner shall take steps within 2 days for service of notice on the respondents by registered post with AD. Full stop. Next paragraph. The Lawrence Senior Counsel for the petitioner has paid for interim relief as his press for interim release as paid for. You have no prayer here.
Page 13.
13.
13, 1, 3.
Next paragraph. Having regard to the where is the copy of the previous order of this court?
This is pay order, madam.
Yes, where is that?
That is 45.
45. Having regard to the order dated 10/4/2023 passed in CRPIO 102 of 2023, whereby the proceedings of TS 237 of 2020 was suspended. The orders which were passed by the learned Civil Judge number 3, Counter Metro Guwahati, on 8/8/2023, and 21/9/2023, shall remain suspended till further orders that may be passed in CRPIO 102 of 2023. Next paragraph. The learned senior counsel for the petitioner shall make a prayer no, don't say that. You said, list this matter along with CRPIO 102 or 2023.
Interim injunction was passed in our favor. Thereafter, we appear on 21 occasions when we are appearing, they are not appearing for the case. And the court is not taking up the matter. Say that unless both the parties appear, I will not take up. That is how the extension is taken. Because he is happy, arrest order is not affecting him. He has started his own business. All right.
CRPIO 343. 4 weeks. 343. Yes. Just a moment. Which page is the impugn order? Page? Page 60. Where is the application? I have not been followed this order. Where is this application under order 21/47, reduced 47? Where is that application? You are the decree holder. You are the decree holder. You are the judgment debtor. Where is that application? Who has filed that application? Huh?
Plaintiff, I'm not the plaintiff, I'm the defendant seller also. The consideration money was 22,50,000, wherein 9 lakhs was paid to me. I'm the seller. Therein, lordship, the suit was filed and the suit was decreed ex parte. I was not there. On behalf of the, in favor of the plaintiff. After that, lordship, executing that case was there. And their lordship, in the cancelled execution case, he appeared by filing one application that is 65 of 18, wherein we have stated that we are ready to go for the registered assembly, provided the money is, the leftover money is given to us. And therein an order was passed by the executive board. Lordship taken that order in page number 46.
40?
46.
6.
Yes. Order dated 3/7/18.
Okay, yes.
The learned counsel for the holder.
I've read it. Next.
Case is fixed today for order on petition of justified that we have filed.
No, that's okay. I've read it. Then what?
Then after this order, lordship may produce the that line, the decree holder is to comply with the decree and take necessary steps for that for that immediately. Decree holder is present in this date. Therefore, Lordship, the next day, 24/7/18, it's in actually is not there. They have the other side, they have filed one application against 22/18. And on that, on 3/8/2018, this order is passed. Very Lordship, the alternative remedy, which is to give back the money, that has been given by the order by the court on vague allegations, Lordship, on the next page, page 48, Lordship, if I fourth line from above, Lordship, the allegations by the other side, Lordship, the petitioner came to know that the defendant JD has taken advance money from different persons, from showing that he sale his landed property to different persons. Moreover, the petitioner came to know that the defendant is a fraud person. Vague allegations also no evidence. And the finding of the court, Lordship,
So on that, it is in this application that this order was passed. Now, what is this application at page 49?
yes, there is the Lordship, we prefer this
Yes.
for this preferred by us for dedication of that 3/8/20.
This is by the decree holder.
Yes.
Recall this order.
Yes. And the
Okay. But Ms. Aydastan comes for the but then would CRP would be maintainable. But this perhaps would not be maintainable. In fact, yesterday or 2 days back, an argument was made, and I have checked the case law. You see, in an it has been held by various judicial pronouncements that 2 days back only somebody made an argument. After that, I've checked the law and I find it the argument is perhaps correct. In a degree of specific performance, the decree passed is a preliminary decree in nature. And when the orders are modified to give alternative remedy, it's a well settled position that it is an extension of the suit. And that modification is an alternative remedy which is prescribed, I think, under 28 of the Specific Relief Act. So that would amount to variance of the decree. And once there is a decree, the only alternative way to touch it is by way of an appeal. Because executing court does not have power to do it. Rescission of contract or alternative remedy in a suit for specific performance. That is order which an executing court can't do. It has to execute the decree as it is. And executing court does not have power to alter the decree.
The change has been done by the executing commission. That is by. Moreover, Lordship, I have also taken the ground, Lordship, because if your Lordship reduce the decree or the plaint wherein the reliefs are given, Lordship, the first, the main reliefs are there, and then Lordship, in the second category, that order 21, rule 34 is also there. So if I have paid and every time Lordship, where the order, in my humble submission and understanding, Lordship, if alternative relief is to be done.
34, the court will execute the decree, shall deed.
Can you Lordship, stated about
Okay. Ms. Aida's counsel for the petitioner. Next paragraph. The order dated. Okay. So what is the impugn order? Page
page 60.
60. (15, 12, 2022). But why you come after 10 months?
This is in fact because it was filed earlier, but from the defective file, the original documents was misplaced. And that's why I did not clear the defective documents.
Oh. 15, 12, 2022 passed by the learned civil judge with bracket senior division bracket close Bogota in Miji case number 6 of 2019, arising in the proceedings of what is the execution case number? Entitled execution case number 7 of 2016. By this application filed under Article 227 of the Constitution of India. Next paragraph. The petitioner is the defendant in title suit number 50 of 2013, whose from the said suit was filed by the respondent for specific performance of contract to enforce the agreement for sale in respect of the suit land. The suit was decreed ex parte. And thereafter, the execution proceeding was initiated. Full stop. The learned counsel for the petitioner has submitted that on receipt of a notice of this execution petition, of the said execution petition, where is that order that you appeared? Where is that? 46. The petitioner has been debtor had appeared on 3/7/2018. Appeared on 4/4/2018 and filed petition number 65/18 by stating that he is to receive a sum of rupees 13,50,000 and on such receipt of such payment, he is ready and willing to transfer the land to the respondent by registered sale deed. And accordingly, the learned civil judge Barpeta had directed the decree holder, the respondent decree holder to comply with the decree. Full stop. Thereafter, instead of making payment of the agreed amount, the balance amount due, the respondent decree holder is stated to have filed and a petition number 229 of 2018. Where is that petition?
Next page. Page,
To return to refund the advance amount of rupees 9 lakh with compensation of rupees 2 lakh. The said prayer was allowed by the learned executing court, i.e. civil judge within bracket senior division, Barpeta. Full stop. You should notice returnable in 4 weeks. The petitioner shall take steps for service of notice on the respondent by registered post with ED. Steps within 2 days. For next para. Having in view of the facts as narrated above, the court is of the prima facie view that a rescission of the alternative prayer for rescission in a suit for specific performance the meaning of section 28 and 29 of the 20, 29 and 30 of the Specific Relief Act, the prayer for alternative relief is required to be taken up in the suit. Full stop. Obviously, the court does not find that the executing court has a power to annul or rescind the decree of specific performance and to pass an order of requiring the judgment debtor to pay the advance amount, refund the advance amount. Full stop. It It also primarily appears that the that although this is the learned civil judge within bracket senior regional bracket goes Bovita is also the court of original jurisdiction which has passed the decree, and it is the same court which is taking up execution proceedings, comma. The application for rescinding the contract ought to have been taken up in the original jurisdiction and not at the execution, not under execution proceedings. In that view of the matter, comma, the court is inclined to stay the operation of the impugn order dated which page is that order? 60 or 15/12/2022 passed by the learned civil judge senior region Bhavita in his case number 6 of 2019, arising in the proceedings of title execution case number 7 of 16 shall remain stayed till further orders. But take steps, otherwise we'll vacate. Don't say that you could not take steps. Take steps. You don't take steps. I'll remember to vacate it. 4 weeks. Yes, FAO 68. Yes, just a moment. Just a moment. Yes, where is the impugn order?
Is it page 156 and it should be
56.
56.
You are the plaintiff or the defendant?
I'm the defendant.
You are the defendant.
In fact,
That's someone. Where is the order we said?
at page 156 and it should be
153.
56.
6.
Order dated 7/9/2020.
Yes. Where is your injunction application? Where is the injunction application?
That is the page number 110. This should be 390.
Where is the plaint?
Start page number 28, my lord.
There are three sisters, all legal heirs. Then we are not inclined to modify the order of the status quo.
If I may just place the facts in the. Can we turn up the page 30?
30.
Para number 4 is the crux of the issue that there were 6 commercial shops on the same plot of. This were built up in the year 2008 itself. 2007, we got it mutated. Even the appellant, plaintiff itself, she was allowed to be mutated. Her name was also mutated along with the 2 sisters. We are dependent appellants of the before. Let me kindly see at para number 4. This is her own admission. For the past 14 years, she did not claim any rent from these tenants who were the shop. Thereafter, she comes up when in the year 2021, when the construction is almost at the end of its structure. 2018, we got the permission from the GMC. She never objected. Passed by 3 years, she approaches the GMC. I'll take my word to the GMC.
No, whatever, but she's once her name is mutated, she's a co-owner.
Yes,
So once you are holding the property, you are holding in her benefit also.
that is the point. Here in Milord, when we filed a WS stating that she had already sold her part of her share from the suit property, Milord, she did not even inform her. And that apart, Milord, pursuant to that, but she took the consideration amount from the person and she got her part separately. That is what our condition, and now through amendment. She
No,
fixed
that condition won't suffice unless you show the sale deed. Have you produced the sale deed?
This process, she herself in her amendment petition says that I have sold one part portion of this portion of.
Where is that?
Well, that is what I'll take my. Will we come at page 144? This is the amendment application. Look, this injunction status quo was granted prior to 2 days, wherein she herself approaches the court and says that, see, we have missed out something in the plea, we want to amend it. Already, Lord, that was a point which we had taken, that she had already sold her portion of.
So show that.
Lord, this is the amendment petition at page 144.
This is by the respondent.
Respondent itself.
Okay,
But we want to amend the figure.
it's okay. Just tell us.
Well, page 146 is the para which they want to incorporate, stating and admitting that she had sold a portion of the
46.
146. 18C is the paragraph. Lord. If I may read, Lord. That at the time of filing the suit, the plaintiff had inadvertently left out to mention that her uncle, namely Sri Babudhar, had sold out a small portion of land measuring 2 lachas to one Mirjan Ali for construction of Writ, and her said uncle sold the land when she was aged about years and asked her to put her signature on the land documents before her marriage, and thus she put her signatures as instructed by her said uncle. The said land was also from her father. The amount of the sale consideration of the said land measuring 2 lessas was only 80,000 only, and that amount had been taken by her said uncle since the plaintiff was staying with her uncle Babudhar from the age 4 to 5 years till her marriage, and the marriage of the plaintiff had arranged by the uncle Babudhar as because the father of the plaintiff had expired. So she admittedly says out of this 2 kathas of land, 2 kathas 7 lessas, she sold her portion of the land. So this construction.
No, her portion we don't know. How you are assuming that out of 2 kata, her share will be only 2 lechas?
This, she had herself admitted that because of the fact, there was a partition mutually agreed between three sisters, and her portion of the land is still kept vacant. We have not touched her portion of the land. That is still vacant, because the construction all over came in the year 2018. And the 2008 year, when the shops
No,
were
this
constructed,
is not acceptable. You see, a partition must be there in meets and bounds. You just can't say that this land is partitioned between the 3 patadars, and therefore this X is his share, Y is my share.
admittedly, she had sold that portion, but the.
She's sold only 2 lechas, and she says that it's not there. It's sold by her uncle.
But she had put the signature, she says that this is her portion, advertently was missed up. But
You see, those things we don't know. When it's a joint pata, we don't know how the share will be determined. She has sold, her share is 2 lechas. How can I assume that?
This is her own condition, because we never will like, lots of will see the WS, wherein we have stated that how she had sold her portion of the land. Because this.
Her portion means, you see, who has prevailed on you to assume that she has sold her share, and her share in 2 kata land will be only 2 lechas.
Out of that portion of land, she had sold 2 lechas, and because of the fact that this portion of land was given to her, we never objected to that portion of the land. And her portion of the land is still kept vacant.
No,
We
no.
have not touched on
When
that
you
portion.
3 have inherited 2 kathas of land, you can't say her share is 2 lechas.
Out of her portion of land.
No. You see, whatever is there, but whatever is remain, she has a right to share as a.
That portion of the thing is there, but the construction now will bring the third party right, because the tenants were already.
Those have to know. Nobody's, you see, those what tenanted portions which are there, nobody's asking them to vacate it. It is only status quo, maintain the construction.
That portion of the land has been demolished. Because the construction has been demolished, because this was a RCC old dilapidated condition shop. We dilapidated, we demolished that construction, and it was about to bring a new construction on those premises. Now, these persons' tenants have been vacated from these premises. And as a result, she had been claiming that the rent should be given to her. From 2008 to 2022, when she filed this, she never claimed this.
No, because you see, it's a well settled law. It is not required to be resettled again. If somebody is you see, there are 2 things. Number one, something is, there's a definition called co-sharer, and there's something which is called co-owner. See, if the father's property is devolved on someone, one is not only a co-sharer, it is a co-owner also.
Since 2008 till 2022, she never claimed that amount of.
So we don't know. There's only a difference in the concept that if there's not been separate share has not been taken, only in Mohammedan law one becomes a tenant in common in Mohammedan law, but in Hindu law they become a co-owner. So you see, let us say in a home, there are 2 brothers. One is staying in Delhi. There are 2 brothers who are the owners of a flat. One brother is staying in Delhi. So the other who's been allowed to use can't say that he has been having a adverse position just because the brother is not there. Adverse position will not, that plea will not be available for a co-owner.
At this stage, we are not saying that she is not having a portion of land in that property. We are saying that we are agreed. And out of her own share, she had now stated that she has drawn.
So, okay, in that, you see, whatever is there, the question is that it's not a case for vacating the interim injunction. The strategy will be more changed, more third-party interest will add up.
Third party rights to clear accrued, but because the tenants who have now been evicted and the shops have been demolished, their livelihood has been definitely affected. Because they have been ousted on the condition that will be reinstated as soon as the construction comes in. And this injunction application of 392 this case was not intended for 1.5 years. Thereafter, suddenly on one occasion, he files a petition that the RCC shops have been demolished. On that occasion, the London trial court takes up the cognizance and then says that yes, we'll allow your status quo order, and then on the finality, this order has come. But it was on this occasion. And presuming the lot that the school lecturer, she says that she has sold out. Because the schedule of the land has not been corrected. But this is a definite wrong schedule on which the premises and even we did, but your lordship will see the schedule here. They don't even mention that there are 6 commercial shops, but the entire anchor sheet is that that the 6 commercial shops were within the boundaries of it. What we'll see at page number 40. They don't even mention that these are the scheduled shops where the injunction has to be there.
Page number
Page 41.
41.
In fact, no whisper of the schedule promises. A plot of land. But already there was one constructed house where she herself was staying. The painted. This is only a whisper of a plot of land. Even the 6 scheduled shops are not mentioned anywhere.
There are only people residing there that they will not be affected. Their easement right to ingress and egress would not be affected. But if constructions come up, third party rights get 55.
That, my permit,
Definitely.
But similar issue came up before the Supreme Court.
Pardon me?
This is 2008, 11 SCC, it's 1. Tali Rangana. I have a copy. At least at para 9 with my lord. By an order dated 22/4/2006, the learned trial judge directed maintenance of status quo. However, by reason of an order dated 12/9/2006, both the IAs were allowed. The order of the injunction as paid for were passed therein. On an appeal having been preferred therefrom by the respondent present before the High Court, the same was allowed by reasons of the impugned judgment directly. But this is important. For the aforesaid reasons, both the appeals are allowed and setting aside the impugned order IAs 9 and 12 before the trial court are dismissed. However, it is made clear that any construction that is going to be put up in suit properties shall be subject to the decision in the suit, and any alienation or creation of interest by the defendant shall be subject to the decision of the suit. If any alienation is made or any interest is created in the suit property during the pendency of the suit, the defendant shall intimate transferees or concerned persons about the transaction being subjected to the decision of the suit and shall mention in the consent document that the transaction will be subject to the decision in the suit. Any creation of interest shall be intimated by the defendants to the trial. Down below, my lord, para number 11, Mr. K.P. Venugopal, Mr. This and the learned Mr. R.F. Nariman, learned senior counsel appearing on behalf of the respondents on the other hand submitted. The partitions having been effected as far as back in the year 1924, and the principal respondents having been in possession of the properties. Lord, in this, my particular case, Lord, she doesn't even prove that she is under possession. She left the possession. From 1956 to 2003, where they granted lease in respect of 1/3 of the property, the impugned judgment should not be interfered with. Even an advertisement was issued for sale of 1/3 of the land in the 1985, and the deed of sale was executed on 22nd. Admittedly, as would appear from the photographs appended in the counter affidavit, huge construction have come upon the lands in question, and as this is important, there was no reason as to why the appellant had kept quiet for so long. A large number of documents have been filed before the court below not only showing dealings with the properties, but also showing execution of the lease payments of corporation tax, income tax, capital gains, etc., which clearly point out separate position of the properties by the defendant. In view of the fact they had been collecting rent, from the tenants themselves would show that the appellants have prima facie no case. That these documents having been filed before the learned trial judge committed a serious error in not taking the same into consideration, and thus the High Court has rightly interpreted thereby by reasons of the impugned judgment. Number 5, the respondents keeping in view the escalations of the cost of the building methods would suffer irreparable injury if they are not permitted to carry out the constructions. The trial court proceeded to consider the matter only on the angle as that whether the appellants would suffer irreparable injury or not without considering the other facts relevant for the grant of injunction, visually, prima facie case and balance of convenience. Then I take my lord to para number 18.
No, but you see in para 14 is a specific finding that the date of partition
Yes.
is 24/6/2024.
Yes.
So that is why the Supreme Court is saying that even if the constructions have come up, they have relinquished the right because of the fact that there was a partition. In your case, there is no partition.
He said that there was a mutually agreed partition. That is why she sold a part of her land. And moreover, your lordship will see at para number 18, how the lordships has said, while considering an application of for grant of injunction. Para number 18. While considering an application for grant of injunction, the court will not only take into consideration the basic elements in relation to existence of a prima facie case, balance of convenience and irreparable injury, it must also take into consideration the conduct of the parties. Grant of injunction is an equitable relief. A person who had kept quiet for a long time and allowed another to deal with the properties exclusively ordinarily would be entitled to an order of injunction. The court will not interfere only because the property is a valuable one. We are not, however, oblivious of the fact that grant or refusal of injunction has serious consequences depending upon the nature thereof. The court dealings with such matter must take all endeavors to protect the interests of the parties. For the said purpose, application of mind on the part of the courts is imperative. Contentions raised by the parties must be determined objectively. The court, take your lordship to para number 20. In Cadbury's India Limited, that therein, however, the question in regard to a valid abduction of daughter was an issue. This court held that Nirmal was not validly abducted. This court wondered. The properties may be valuable, but would it be proper to issue an order of injunction restraining the appellant's hearing from dealing with the properties in any manner whatsoever is the core question. They have not been able to enjoy the fruits of the development agreements. The properties have been sold for a long time. The commercial property has not been put to any use. The condition of the property is remaining wholly unused to deteriorate. These issues are relevant. The courts below did not pose these questions unto themselves and thus misdirected themselves in law. Emphasis was also laid on the conduct of the parties while granting an order of injunction. In Seema Arshad Zahir versus Municipal Corporation, this court held the discretion of the court is exercised to grant temporary injunction only when the following requirements are made out by the plaintiff. Existence of a prima facie case as pleaded, necessitating protection of the plaintiff's right by issue of a temporary injunction. When the need for protection of the plaintiff's right is compared with or weighted against the need for protection of defendant's right or likely improvement on the defendant's right, the balance of conviction tilting in favor of the plaintiff. Clear possibility of irreparable loss being caused to the plaintiff if the temporary injunction is not granted. In addition, temporary injunction being an equitable relief, the discretion to grant such relief will be exercised only when the plaintiff conduct is free from relief and he approaches the court and clean matter. This paragraph 23 is important. Rightly or wrongly, construction have come up. They cannot be directed to be demolished at least at this stage. Respondent 7 is to be said to spend 3 crores of rupees. If that be so, in our opinion, it would not be proper to stop further construction. We therefore are of the opinion that the interest of justice would be served if we allow the respondents to carry out constructions of the building. The same is made subject to the ultimate decision of the suit. The trial court is requested to hear out the dispose of the suit as early as possible. If any third party interest is stated upon the completion of the construction, the deed in question shall clearly stipulate that the matter is sub judice and all sales shall be subject to the ultimate decisions of the suit. All the parties must cooperate. Similarly, in this case, it was made subject to the outcome of the suit. In any case, if the construction comes up over there, the part of the construction which will come in will very well can be compensated. But the irreparable loss as of date is on us. Because we have demolished that part of the construction and these persons are not able to get their things back. The basic thing is that the third party right to back. And even she is claiming that the tenant should have given the rent. But all along, these tenants were never claimed. She did not even claim from the tenants that this amount of rent should be given to her.
No, Mr. Vithara, this case you have cited, I don't know how it will help you. In this case, what has happened is that the land was purchased, land was partitioned in 2000. What is it? 2020. Partition was in 1924. Now, look at paragraph 11(1). After the partition in 2024, the principal respondents have been in possession of the suit property from 56 to 2003. Correct. Thereafter, they leased out 1/3 of the property. They even gave an advertisement. So therefore, they were possessing it adverse to the interest of the other side when there was a partition. Now you come to the next page. Page 3, last part 3. A large number of documents have been filed before the court, before the courts below, not only showing dealings with the properties, but also showing execution of deeds of lease, payment of corporation tax, income tax, capital gains, etc., which clearly point out separate position of the properties by the defendants. So therefore, in this case, there is a specific finding of the Supreme Court.
But in our case, we have projected that the GMC application for construction, we have left out that portion of the land. That portion of land is still vacant. We have not touched a portion of the land, leaving that as.
No. You see, in between three sisters, which is which portion, who will decide?
This was only on this juncture, that we started our construction after the year, in the year 2018. She filed a suit in the year 2022. Knowing it very well, that this portion of the land has been left out. She is now eyeing up on the property which has, on the construction which has come out. We would not have left her portion of the land in case we would have any. And the portion she sells it up, and she brings it only after we file a WS to the effect that this portion was already sold by you to her person from your remaining portion of the land. You took this consideration and did not share.
Where is your stand in the written statement?
I'll just take. The relevant point is at page number 92.
90?
92. That is internal page number 10. Specific stand, my lord, I'm taking.
92.
Yes,
Para?
I'm sorry, my lord. That is at page number 85. Page number 85.
Yes.
The third line where it starts. And as my lord, under Jhalugadi Modern district, but in reality, only land measuring 2 katha 5 lechas is in the possession of the three sisters. Although the record shows that the area of the land is 2 katha 7 lechas. Thereafter, in this para number 11, if I may start from the second subpara, that the actual fact is that the defendant number 1 has constructed the commercial shops on the portion of land which had been acquired by her and per the mutually agreed partition in the year 2007. Amongst plaintiff and defendant since long time, the seed shop has been constructed by the defendant number 1 on her own cost in the year 2010, and during the time of the construction of the shops by the defendant number, she had not received any claims or objection from any corner. That the defendant number 1 and 2 on their own cost developed their portion of the land and made their portion of land valuable. And when that portion of the land became valuable, when the plaintiff had put her eyes on it with an evil intention to extract illegal gain from the answer. This is important. B, it submitted that the three sisters had inherited the plot of land measuring 2 kathas 7 lachas in total from the deceased father. Therefore, each sister was supposed to get land measuring 15.66 lachas as the share of the land of each sister. But at the same time of mutually agreed partition of the suit land, each sister had actually acquired equally share of measuring 15 lachas. Because of the fact that in reality, land measuring 2 katha 5 lachas only had remained in possession of the three sisters, because of the fact that in the year 2016, the plaintiff had transferred the possession of land. But here we say approximately 2 lachas to a person, namely Mir Jan Ali, for a consideration of 40,000. Without the 4 lakhs, without the knowledge and consent of the defendants on their back, and the person, namely Mir Jan Ali, whose house is adjacent to the house of the plaintiff, has constructed a pakka drain having dimension approximately 130 to 2.2 feet over the transport plot of land. So the schedule apparently she does not even mention that the Mir Jan Ali is also on the northern side of the land.
Where is that petition for injunction?
But that is the 390.
Three,
390, sorry, 110. So in fact, there were three applications. First one was mistake is 89. For the same issue, that there has to be a status quo order on the country. Secondly, the second petition was this 390. Thereafter, one more petition was filed, that was number as 3840/2022. That is at least 133. Three petitions on the same issue were filed to grant an injunction.
second petition is where?
The second petition at page 133. 3840/2022. Same.
What has happened to the other proceedings? What has happened there?
So these three were merged together and this order has. The first order on 392 was that the court will not pass an order without hearing the opposite parties. We were the defendants there in the first order was there. Thereafter, she files another application that is 89. Then 392. Then the third one was 3840/2020. Three applications were taken. At that juncture, the court did not allow any injunction. It was only.
And where is the amendment application?
That is the page number 144. It starts 144.
44.
They projected that a new construction has come in on the shops. Because on this premises, this injunction was granted. It was not on the suit limit. It was on the construction. And these readings of 392 is silent about the construction of shops. It was on the building. If I may read the prayer, prayer in 392 is on the construction of buildings. But this is injunction is on the suit property of commercial shops.
Where?
But 390 people will take that. The
Page,
prayer-
page.
Yes, madam, I'm just taking. 112 madam. This is the injunction application that the injunction is granted. Page 112 madam. Prayer, madam. It is therefore prayed that your honor would be pleased to admit this petition and be pleased to put up the case record of title suit 70 and Miss J case 89, and after perusal of the entire facts, your honor we kindly be pleased to pass the restraining order restraining the opposite party from construction of the RCC building. But if your lordship goes through the impugn order, this is a construction stay on the shop premises. That a shop premises is now about to be constructed, so that has to be status on this product. The entire shop plot of land is a one and single plot of land. And it is only on the front portion where we started, we demolished this process and we were about to construct this. Well,
Where is application for order 39 rule 1 and 2? Where is that?
This week is 89.
Where is that?
Page 63.
63. What has happened this 89?
This was also merged in first order of 89. The court says that without hearing the opposite party, that order also by an expert. That the court says that we will not allow you status for injunction until and unless we hear the other party. Notices were issued therein. This matter was not taken. Time and again, he files different applications. One was 392, which your lordship has seen. Thereafter, there was 392. 1308, 3840, the third application. Three applications were filed.
Your lordship has seen at page number 63, this is mistake is 89.
Okay, let me consider because I am running out of time. I'll consider in pass orders. It will be released on tomorrow. Yes, for others, I may not have time to take up today. There was an, yes, Mr. Udin.
57 and 78. Yeah, these are fundamental of delay petition to RSA. Because of some procedural error, two separate RSA or been filed but single file.
77, 78.
28, 77. Yeah, but execution proceeding is pending, my lord. Therefore, we are, my lord, some advance. Only notice advance is there.
What are the both applications?
Both are, my lord, yeah. My suit was dismissed and.
No, what is this IA? What is this IA for?
IA for protection notice.
You want to issue notice to be
Only
issued?
notice.
Okay. 76 and 77.
77 and 78.
Huh?
77 with 78.
77 and 78. Right? 77 and 78. In 77, delay of 584 days.
In 77,
Yes.
delay of
In 78, delay of 375.
no, in 77, say one by one.
27, delay of 584 days.
77, 584 days.
580.
Condonation application, section 5, 584 days. Item 78,
375 days.
okay, notice steps within 2 days, return in 4 weeks.
Fine.
Yes, there is one more matter, 76, what is that? 76 also your name is shown, Mr. Udin.
77 and 78.
But 76 is yours,
Yes.
then we dismiss it. Two good orders and one bad is okay.
Other 78 for stable.
It is normal because already.
Stability. 76 and 77 are.
I'm sorry, 76 and 77 for condition of delay.
How much delay? 76, how many days?
584 days.
584, you are sure?
Yes.
You have seen your brief?
Yes.
78 to item 78 to filing number. Already
77
or
3207, IA.
77 is 375 days.
Yes.
Okay, not 70, 76 and 77. Okay,
May I please-
so you're taken now with my pleasure to dismiss your matter. Okay.
This is for Eastern, so it will come.
35,
35. I know.
For withdrawal of the 50% deposit amount.
35. Who's for the, who's for the insurance?
Yes. This is it.
She's not there. We're trying to find out if she's present, we'll pass on order, otherwise. Let her defer. You're there? No objection? 31. Ms. Mr. A.B. Dey, counsel for the applicant, and Mr. R. Sharma, counsel for the opposite party. This is an application for allowing the applicant, applicants of the claimants to withdraw the money deposited. No, sorry, part of the declared amount, awarded amount deposited by the opposite party before this court. In connection with orders passed in IA civil, 989 of 2020. No, one by one. I can't pass two orders together. This the law and counsel for the opposite party has no objection to the said prayer, so according to prayer is allowed. The registry shall forward the applicants to withdraw the money lying money deposited by the opposite party in the hearing before the court interlocate the application on being satisfied with regard to the identity of the applicants. Full stop. The application stands disposed of. That is 31. Okay, 30.
1 and
17.
7.
70. Same prayer. How much amount in 31?
About 18 lakhs, 2,500.
No. How much amount is to be released? Tell the amount. But there must be specific, otherwise we don't know what will happen. You tell the amount, give the amount to the to the court master. Correct. Give a specific amount, otherwise it will be deferred. Item 70, save. Just get that number. IE civil
933.
933 2023. Okay. Past by orders, past insurance. Okay. So just give the amount to the court master.
The main case to be 4 weeks, main case.
Main case 4 weeks.
4 weeks.
LCR has come in the appeal? No. LCR is there. 31 is in the main case. LCR is available list after 4 weeks for hearing. Service is complete. It is submitted the part that the case is ready at the last service and LCR is received. And item 70. 70 just say the list after 4 weeks. The main appeal. Yes.
And I have legal lordship. Lordship item 36. I have filed an IA and it has become infructuous, your lordship. So I want to withdraw this.
Okay. Both sides are represented on the prayer made by Mr. D. Bandar on counsel for the applicant. Is permitted to withdraw this application on being rendered infructuous. So accordingly, this application stands closed on withdrawal. 36.
Another item 43. This is listed for the first time. Delay.
43.
43.
Okay. Delay of how many days?
1084.
1084.
Yes.
This is for enhancement.
Yes.
But 1000 is more than 3 years. You'll have to tell us why. How much? Why this delay?
Lordship, it has been listed for the first time. So
No. If you're not satisfied, you can dismiss it right now. There must be some cogent reason. 1000 days delay, we can't condone like that.
The reason is that they were not aware of the passing of the award. It is
Oh, no,
only
that
after-
can't be accepted.
in your
That can't be
lordship-
accepted.
in your lordship, it can be adjourned.
Huh?
Can be taken some other days.
Okay.
Item number
Obliged.
35 notice, it will be listed tomorrow. That's how it's stated.
Huh?
35 notice, it can be listed for tomorrow.
No, tomorrow we are not taking up because I don't intend to sit like this tomorrow. It comes after vacation. We'll post it immediately after vacation. This is on 1310. 1310 is open. Sorry, not what do you call 1011. 1011 is open.
1011, 1011.
1011.
Item 35, 1011.
Item number 40, there is a interim arrangement 40.
Item
40.
40. Okay, 40 interim order extended. List after vacation.
where I have stated that only the Xerox copy of the arbitrary award is delivered to the.
Yes, yes, I remember.
So, okay, I am bringing it to the next worship. That is in paragraph 3 of the state petition, as well as in page number 7 of the main application.
Just one, give this record. Item
Item 74.
74. Just wait for some time. I'll dispose of other matters and take up this.
47.
Yes.
I hear
47.
47. Her party have already appeared. Her party is already left.
So we listed after vacation. It has to be passed in their presence.
Yes. 10.
List after vacation.
On 10.
Okay, 10, 11.
10.
Okay.
My lord. Okay.
Yes.
Item number, there is an interim one.
Which item? 60? Level 6. Okay. You have taken steps, respondents have appeared.
We have filed also justice service, they have refused, they have filed an
Just see item 66. 66. Yes, another matter.
Basically, item number 80.
80.
there is a stay order that will continue after vacation. Item number 80, supplementary.
It is after interim order extended.
66.
No, you'll have to take fresh steps. This justice service is not acceptable. I would say upon concept of the petitioner. It is noted that provide additional affidavit filed on 6/10/2023. By the petitioner number 7, it is posited that the respondents have refused to accept the service of notice. Full stop. There are no independent witnesses to the service of notice, and therefore the said affidavit cannot be accepted as a proof of refusal of the respondents to receive service. Stop. Next para, it is seen from the office note dated 9/10/2023 that answered notice and ID card has not been returned. So therefore, the petitioner shall take first steps for service of notice on the respondents by registered post with AD. So the learned counsel for the petitioner is permitted to collect the postal receipt number and submit postal track report prior to the next digital listing. Within 2 days, steps within 2 days. Next para, interim order passed earlier stands extended till the next digital listing. 2 days, today and tomorrow. Tomorrow you'll have to take it. Otherwise, there is again a default. No, and then the what you call, since execution is being stayed, that is the difficulty. We can't give a. I'm not fixing a date after vacation. It will come 4 weeks. It will come after 4 weeks.
Item number 81, supplementary list. Interim order service is available.
81.
Yes.
Okay, after vacation, interim order extended. Yes,
Item 61, item 61, supplementary.
51,
61.
61. Yes,
Lordship, interim order is there, that may be continued.
you have taken steps for
Yes,
service.
Lordship, as per the last order of Nazima Court, service completed, Lordship. Lordship, matter may be come up for hearing, for admission hearing.
Lazio means it's deemed service.
Yeah.
The interim order of the court, did you give it to the trial court?
Yes, sir. Yes, sir.
Oh, okay. Let's start a vacation. Interim order stands extended. 61. Okay.
Yeah, please, my lord. Item number 83 of the supplementary dispute, there's a interim order. But that may be continued.
83. Okay. Let's start a vacation. Interim order extended.
Item number 63, there is a interim
60,
3,
63.
there is a interim.
Okay. After vacation, interim order extended.
Okay.
Yes.
Wait, Mr. Lordship, item number 79. There is an interim stay. That may kindly
79.
7.
Okay. After vacation, interim extended. 79. Okay. Yes. So
My lord, item number 71, my lord, in the RSA, my lord, there is 17 days delay. So my lord, in that delay, my lord, this honorable court was issued notice, my lord. And after issuing notice, my lord, report has come up that some of the respondent, that means that 2 respondent has been expired,
okay.
the long back. So we have already filed a substitution petition. But my lord, the registry has notified that substitution has been, my lord, already expired because the persons were died long back. So my lord, we have already filed substitution petition along with abatement as well as limitation in the substitution abatements. There is a delay of 62 days in filing the abatement as per the registry. But from it, we counted it from the date of knowledge. We came to know only from the report, from the notice. That report has come up that this person was found.
But still, in this application before implement, we'll have to issue a notice.
My lord.
We'll issue a notice then.
My lord.
Which is the limitation application, IA number?
My lord, limitation, my lord, RSA, my lord. Or my lord, first, my lord, this 2981.
No, the setting aside abatement.
Yes, to the 2981, my lord.
2981. 2981 is the limitation application.
My lord, is substitution.
In setting aside abatement.
Yes.
Okay, in 2981, say there's a delay of 89 days beyond the period of limitation in filing the connected substitution application for setting aside abatement and substitution. Post issue notice returnable in 4 weeks. The petitioner shall take the applicant shall take steps within 2 days.
Other respondent already appeared, madam. Only 2 persons, those who are expired, madam. Their legal hair has to be.
So that is a you issue notice only to them only.
Lord, yes, madam.
in substitution application, you don't make everyone parties.
Yes,
You have made everyone parties.
my lord.
But to the notice on the parties sought to be implemented as legal representatives of deceased respondent number
My lord, 6 and 10 one.
6 and 10 within bracket 1.
1.
Okay. First is in 2 days, notice remain 4 weeks, list accordingly. Next is in tomorrow.
Right.
Okay. Yes.
I think 68, man.
60,
68.
68. Yes, what is this IPO? Early hearing. We'll have to fix it after vacation. Because in the absence of parties, we are not passing orders. You are there? Oh, acha. The paucity of time matter could not be taken up today, list after vacation. Liberty to the counsel for the applicant to make a mention. If it is not listed, make a mention. Yes,
My item number 75, Lordship.
75.
75, my lord, I have filed this I matter for correction of order. Lordship may just see
What is the correction of order?
75. Only the number, case number 75. I will find the order at page number 11 of my IA.
Yes, which number?
Page number 11, Lordship, the order, Lordship. At the page number 12, that is page number, internal page number 2 of the judgment, Lordship,
Yes.
or the order, Lordship. The miss case, senior division in Miss J case number 27 of 2002, Lordship. That has to be 22. Twenty-two. 2022. And Lordship, same thing, Lordship, in page number, the next page, Lordship. Lordship, may kindly see, till returnable date, further proceeding of Miss J case number 27 of 2002 again. Lordship, may kindly, this case is already disposed of, Lordship, so there cannot be a stay of this, only the title suit, Lordship. So Lordship, this in struck off, only title suit will remain. Of title suit number so and so, of 96 of 2020. Highly obliged.
Your Lordship yesterday directed me to bring to your notice, Your Lordship, about the statement for receiving only the page number 7 of the appeal, and in the stay petition, it is in page number 4, Your Lordship. Yes, Your Lordship. In point number 3, Your Lordship, page number 4. The respondent has already filed a money execution case number before the Honorable Additional District Judge Kamrup at Guwahati for execution of the arbitration award dated 9/1/21, of which the petitioner has only been served with a Xerox copy of the said order, for which the petitioner is unable to annex any original or certified copy of the same. This was to bring your notice.
Mrs. Sharma, counsel for the applicant. This will be in 3199. You should notice on this application under section 5 of the Limitation Act for condoning the delay of 500 days beyond the period of limitation in filing the connected appeal. Notice steps within 2 days. Notice is made return. Give a fixed date. After 5 weeks. 29/11. Okay.
Your Lordship, may it be before 29, Your Lordship, because the next date of the execution proceeding is 20 of 11, Your Lordship.
Okay.
So if it's possible to come before that.
Huh?
Because Your Lordship, the execution proceeding date is 20.
20.
Yes, Your Lordship.
Okay, it is 20.
That's why if it comes before that,
It's okay. 10/11/2023. The learned counsel for the applicant is permitted to route the process to route the notice to the registry of court and email the notice to the respondent.
Your Lordship, we may not have the available the email ID.
HDFC Bank, you won't find email address. Is
Email
it
address.
possible?
Yes, Your
Every
Lordship.
bank will have an email address.
Yes, Your Lordship.
Correct. Easy to find email address of a bank. Correct. Sorry, this is an addition. Because you have to be, you have
Yes,
to
Your
serve.
Lordship. Yes, Your Lordship.
In addition, notice will be served by registered post with AD as well as in addition by email. This on 10/11/2023.
Highly obliged, Your Lordship.
You know the relevance of what you are showing us today. You know the relevance.
Yes, Your Lordship.
What is the relevance?
Your Lordship, the relevance of, Your Lordship, the relevance
Today,
of,
what you have shown, what is the relevance? Can you tell us?
relevance of our main appeal, Your Lordship.
No, whatever you have shown us today, you know what you have shown today.
Yes,
What is the relevance? Are you aware?
yes, Your Lordship.
What is the relevance?
This section, according to section 31, subsection 5 of the Arbitration Act, the signed copy or the certified copy has to
Correct.
be served.
So that was the
Yes, Your-
first thing you should have said. You would have saved 2 days' time. Correct?
yes, Your Lordship.
When you are handling a matter, be very thorough with that provision.
Yes, Your Lordship.
Correct. Yes.
Highly obliged, Your Lordship.
Because you are the young generation, you must take the mantle.
Yes, Your Lordship.
So reading is the only thing which you can do.
Yes, Your Lordship.
Correct?
Yes, Your Lordship. And highly obliged for hearing me, Your Lordship.
Because if certain things you can't say, maybe it led to dismissal of your appeal.
Yes, Your Lordship.
That is what I was thinking on that day. 500 days delay is not very easy to condone in the arbitration application.
Yes, Your Lordship.
Okay.
Obliged, Your Lordship.
It was just to see a young lawyer arguing, I gave an additional time to find out and satisfy the court.
Yes, Your Lordship.
Correct. So every time you don't get that opportunity.